Guys, hear ye, hear ye, hear ye, all persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning, everyone. Is that on? It is. Welcome to the Appeals Court. I am Justice Rubin. To my right, Justice Desmond. To my left, Justice Singh. We will be your panel this morning. We will be hearing 5 cases. If I can find all the things I need. We may take a break after 3, and we may not. And the rules are as they always are, 15 minutes per side with no rebuttal. And our first case is number 23-713. I remind the parties that this is an impounded case, and so we're not going to use names. And we will hear first from Attorney Toomey.
Good morning. May it please the court, Dennis Toomey on behalf of the Juvenile. We're asking you to reverse the suppression order. The motion judge erred in concluding that there was an objectively reasonable suspicion that the juvenile was presently armed with a firearm. Juveniles, especially black and Hispanic children who are repeatedly stopped and FIO'd and frisked by police, these children need to be able to walk away from police without the act of walking away being used to justify the stop and frisk. I cited Commonwealth v. Warren, 475 Mass at 538, but I just want to read one quick quote. Unless reasonable suspicion already exists, our law guards a person's freedom to speak or not speak to police. A person may choose to walk away. That's what the juvenile chose to do here, and yet the motion judge used that walking away as the primary factor to justify the warrantless stop and frisk. Besides walking away, the only other claimed fact was the nondescript bulge that the officer claimed to have seen. Now, you have the body camera footage that you'll review de novo.
So it seems to me that the court seems to put some stock in, or at least there's some discussion about the juvenile has had previous encounters with this particular officer, seemed to be friendly, cordial encounters, and the fact that he walked away was behavior that he thought was out of the ordinary for this particular juvenile. They seem to put some stock in the fact that he had a Rockets hat on, which seems to be indicative of perhaps some gang affiliation with the Ruggles Street gang. And finally, it seemed that there was some mention about the various music videos that he was in on social media with what they claim are gang associates. So, first off, what's a gang associate? Do you know what that is?
Thank you. So that was not defined in this case, and in fact, the officer did not testify that my client was a gang member or a gang associate. He suggested that my client was seen in music videos with members of a gang, and he suggested that people that wear Houston Rockets hats may be associated with a gang. But the police have a gang database. They have a list of people who are in gangs. They have a point system that they use to identify. You didn't hear any testimony about any of that in this case, because my client was not in a gang. Now, whether or not he was associating with people who are in a gang, that's a different question. But even if he was, there's case law from the SJC in this court, and Pierre P. is my favorite case, 53 Mass App Quarter 219. Associating with the group does not create a reasonable suspicion that you're presently armed on any particular given day. If that was the case, then police could just search everyone who knows a gang member any day, any time.
But this had to do with the bulge in the pocket, right? It wasn't his association. It wasn't his walking away. It was the bulge in the pocket that attracted the attention.
I believe that the walking away and then the officer claimed to see a bulge, you're right, Your Honor. That is one of the reasons the officer used for claiming.
I thought there was testimony on cross-examination that he had seen the bulge while they were back at the bench area or whatever.
Yes, he did.
Okay.
He did claim that he saw the bulge before he turned his body.
Well,
to
because
the
on the video, it's very difficult to see a bulge, and that he was cross-examined about that, and so he's,
I
okay.
agree. But even if he had seen a bulge, which is dubious, but even if he had, on the body camera footage that you'll review de novo with no deference to the findings, you'll see that the juvenile is simply walking away calmly. He's not looking backwards nervously or furtively. He's not blading his stance. He's not touching his waistband. He doesn't have his hands in his pockets. He's not changing direction numerous times to lose him. He's just walking back to the residence, which
Was he
he's
walking
entitled.
back while someone else was creating a distraction?
No. I don't think the motion judge found that. There was testimony that another person there said, hey, are you the same officer who stopped me last time? I'd argue that's not a distraction. In fact, that's probably the reason the juvenile walked away. These police officers had been hassling this group for numerous times. How many times do police have to FIO a person before they can walk away? They're supposed to say hello and be cordial every time? This is an endless, demoralizing cycle. The police, if they find a gun on someone, they arrest them. But if they don't, they call it an FIO and they move on, and no one hears about it.
Did the juvenile walk away as soon as he saw the officer? Was he the first to walk away?
He was not the first to walk away. The officer testified his attention was drawn to two other people in the group. They didn't have a specific age, and the officer didn't know them, but he did notice that a few other people had already started walking inside, and then the juvenile started walking in too. The testimony was unclear as to whether the juvenile saw the officer, but that was the inference the judge drew, that the juvenile saw the officer approaching, and then he decided to go back inside to the residence. And this is a private apartment building. This is not a street stop. So the officers went onto the property of the apartment building where the juvenile and other people were congregating on a bench on a summer night. The juvenile was just walking back inside when he was stopped. So this is kind of unique because there was no traffic stop. The officer testified he stopped the juvenile just to effectuate a pat frisk. And then, as you'll see, he ran after the juvenile, grabbed him, wrenched his arm, kicked his shoe off, and immediately pat frisked him.
There's no question here about the lawfulness of entering that private property?
No, there's not. I believe there's some disappointing case law about an open parking lot for an apartment complex not having...
It's not the curtilage of the home.
Correct.
Okay.
So we did not challenge the entry. But I do think that's also telling. The police are not responding to a reported gun crime or any crime at all. These are just people sitting outside. And then when the juvenile chose to walk back inside, that's when the officer chased him and grabbed him and frisked him.
I don't know if he chased him. I mean, I saw the video myself. It doesn't appear that he chased him. It doesn't appear that he kicked his shoe off. I mean, I don't like embellishing going the other way, but I don't like going this way either. I mean, it seemed that he followed him. He accidentally stepped on his shoe. He apologized.
Yes. No, you're right. It was not an intentional kicking of the shoe off, but the shoe did come off. I just want to briefly talk about the Commonwealth raised an alcohol issue in their brief, that there might have been reasonable suspicion of underage drinking. The motion judge correctly did not find that there was reasonable suspicion that the juvenile was drinking alcohol. The officer testified and he admitted he did not know if there was any alcohol in the cup the juvenile was carrying. The officer never saw the juvenile pour any booze into that cup.
Was there testimony that there were 6 kids in the back of the building, 1850, I think, Washington Street, or six people? Some were adults, some were juveniles.
Yes, correct. But most importantly, even if you had found somehow that there was reasonable suspicion to stop because of alcohol, the pat frisk would still be unconstitutional because for the pat frisk, you still have to have reasonable suspicion that the juvenile is armed. So no matter what, you have to answer that question.
If we disagree with you about reasonable suspicion that crime is afoot, what creates reasonable suspicion that someone is dangerous? You make a distinction there, and I'm having it seems complicated to me a little.
It does, and actually, pursuant to my ethical duty of candor, the Commonwealth sent me a case last night, very late, that neither of us cited, but it is relevant to this Commonwealth v. Guardado, 491 Mass 666, which seems to suggest that if there's reasonable suspicion that a person is armed, and if there's proof that the armed firearm is an unlicensed firearm, then you can assume that the person's also dangerous.
Can we assume that if a juvenile has a gun, he's dangerous?
Well, that's the question, that case. And again, I think this case does turn on whether there's reasonable suspicion that the juvenile had a gun. There was no evidence as to what the bulge was.
But can't we say if a juvenile has a loaded firearm, then that's dangerous?
Well, this case that I just...
By definition.
This case that I just mentioned seems to suggest yes, Your Honor. I do need to concede that.
So why don't we get back to the question you're saying this turns on, whether there is reasonable suspicion that he was armed at all?
Correct. I think a nondescript bulge that could be so many things is not enough. There was no testimony that the bulge was shaped like a gun. Again, none of the typical factors that this court and the SJC cites, blading of the stance, furtive look backwards, belligerent behavior, extreme nervousness. There's no informant tip about a gun.
There wasn't any testimony that in this officer's training and experience it appeared to be a gun? That's why he went after him. That's why he followed him.
He did testify that in his training experience, he thought it might be a gun, yes. But he didn't testify that it was shaped like a gun. He just testified that it was a bulge. And it was really a hunch. And the cases I cited in my brief point out that...
Does it matter that it was on his hip? Does it matter that although it was under his clothing, it went above and below the waistline? I mean, those are 2 points that are made in the testimony. Do those things matter?
I don't believe so, Your Honor. There are many things, a fanny pack, a phone clipped in there, something in the pocket, an overweight person with fat rolls. There are numerous things that could cause a bulge in that location. I think you need more. You need something. Otherwise, you're just guessing as to what that bulge might be, and that's the heart of this case. The officer was just guessing. This is an officer who his job is really focused on getting guns off the streets, right? And that's an admirable police safety goal, but it runs afoul of the Constitution when they're doing this in a manner that really is unreasonable without specific articulable facts as to what that bulge might be. The only other factor that the judge mentioned was high crime area. And again, this was at a residential building. There was no testimony that 1850 Washington Street was a high crime building. And the high crime area, as you know, it's really almost a meaningless factor. Washington Street, which he testified is the high crime area, is a lengthy street, including many innocent people. My wife and I go to my favorite restaurant, Toro, for Spanish tapas. It's like a block up from this house. So I'd urge you to not put any stock into the high crime area claim. But I do think...
It's over by Lenox Street. I mean, it's arguably a high crime area, notwithstanding that folks don't get to choose whether they live in there or not in some respects. So, I mean, you're on Washington Street on that side of Mass Ave, up by the Lenox Street projects. I mean, those are areas, I think he testified that he's responded to a number of firearm and firearm-related instances in that area.
Yes, but not at this apartment building. I think that's my point, that if this was a street stop maybe, or they were responding to a reported crime, it would be different. But this is just people sitting outside their apartment building. Suppression, I would urge, is needed as a deterrent in this case. I think people need to be able to walk away without the act of walking away, justifying the stop. And police need more than seeing a lump in someone's clothing if they're not responding to a crime or an informant tip. This is the kind of overzealous police action that can really sweep up a lot of innocent people and violate a lot of constitutional rights, including my client's rights in this case.
Do you have a case that says that you need a further description than I saw that the person had a bulge in their waist based on my training and experience? This is consistent with someone carrying an unlawful firearm.
No, but there's also no cases that say just saying you see a bulge is enough either. I think all the cases, where bulges are mentioned, there's additional facts.
Right, and this additional fact was not I saw a bulge, but this, in my training and experience, this bulge was consistent with someone carrying a firearm.
Well, I think in the cases I cited say subjective claims of training and experience are not a substitute for objective facts, because...
I don't remember. Did he say that? I didn't see that.
I don't recall that exact language, Your Honor, but he did mention that...
And he said he found it suspicious or thought it was a firearm, and in cross-examination there was a lot about why couldn't it be a water bottle, and all I think he said was... Actually, I don't know what he said about water bottle. He said, it obviously wasn't a phone or something, I thought he said.
Correct. I think he did say it could have been a water bottle, but he usually sees kids carrying water bottles in their back pocket, not the front. But he did claim that he relied on his training experience, but I don't believe that he specifically said, based on my training experience, I know that bulge is a firearm. And so I think that's why.
I think you're saying even if he said that, that wouldn't have been enough.
I agree, yes. There needs to be something that you and the motion judge can objectively review so that this is not just a police officer using his hunch. Again, if he had testified that the bulge was shaped exactly like the outline of a particular gun, which he did not do, maybe that would be enough. Or if something was protruding, or any of the other factors, if the juvenile was touching the waistband at a certain location. But they needed that additional plus factor that was missing in this case. I can see that I'm almost out of time. If there are no further questions, I'd ask you to reverse and rest on my brief.
I see nothing else. Thank you very much. Interesting and excellent argument. And we will hear now from Attorney Sicanolfi.
Thank you, Your Honor. Good morning. May it please the Court. Kyle Sicanolfi for the Commonwealth, asking you to affirm the denial of the motion to suppress in this case, given the fact that a set of information united in this particular context, giving rise to reasonable suspicion that the juvenile was carrying a firearm, and that it made it rendering the officer's belief that the juvenile was armed and dangerous to be objectively reasonable. That set of information is what the officer observed about this juvenile on this particular night, what he knew of the juvenile from his past interactions with him, and what he knew of the area in which he encountered the juvenile on this particular night, all in light of his training and experience and the very purpose of his assignment within the Youth Violence Strike Force. The juvenile in this case, it was earlier raised, at what point did he walk away from the group? And there was testimony from the officer that the juvenile did an about-face immediately upon taking observation of the officer approaching, and that this occurred after two others had departed the group. But there is testimony from the officer that once the juvenile saw him approaching, he, at that time, did an about-face and removed himself. And it was in that moment that the officer observed the bulge at his hip and began to follow him through the parking lot. He observed, it was significant to him, the juvenile's behavior on this night was markedly different than the juvenile's past interactions with the officer in the 2 to 3 months leading up to this particular night, where he encountered the juvenile on 2 occasions, where the juvenile was in the companionship of people who were arrested for firearms. Even in those circumstances where his companions were being arrested for firearms, the juvenile was cordial. He was joking and chatty. But tonight it was different. He wanted nothing to do with the officers. And that may well have an innocent explanation, and he deserves the right to be able to walk away and not engage with police. However, it doesn't render the officer's understanding of the significance of that behavior unreasonable, particularly given the rest of the factors that were known to the officer at the time. In terms of the bulge that he observed, he did state that it appeared to display above and below the waistband, and he described in his training and experience that concealed firearms will be held in this way. They're not holstered. They're kept in the waistband, resulting in a bulge. When he described the bulge in examination, he stated that when he saw it, that was his belief and his concern. It was a concealed firearm based on the type of bulge he saw. When he got up, he gestured and confirmed to the prosecutor.
I don't see any place where he says his training and experience told him that it was a firearm because it went above and below the waistband. Can you point me at that?
I would say that that is a reasonable sort of bringing together of the testimony in this case.
No, he doesn't say it.
Well, he testifies that his training and his experience is that unlawful guns are carried in the waistband, not holstered, and they result in a bulge. And when he testifies about the particular bulge and how it appeared in this case, he describes it appeared above and below the waistline, and that bulge for him was consistent with a firearm. I believe that's in the transcript at the in the area of pages 25 to 27. So, I don't think he gave the sort of definitive opinion at that time, but reading the testimony in total, that's what he's communicating, that when he saw this, based on his training, based on his firearms experience, that was what he believed he was observing and not some innocuous item. And that was also given the other factors that were present in this case. This was a area where the unit was on a directed patrol. They were specifically in that particular area of Washington Street due to the volume of active shootings, armed gunman calls, and in the course of doing that focused patrol is when they encountered the juvenile. The officer knew from his experience that there are certain insignia that area street gangs may use to identify themselves, their membership. His encounter with the juvenile on a prior occasion, he was wearing an insignia that in the officer's training and experience was one utilized by an area street gang, the Ruggles Street Gang. So too this night, the juvenile was wearing that. And perhaps there would be an innocent, completely understandable explanation for that. But it was telling in the officer's encounter previously with the juvenile that he couldn't identify any of the sports players associated with the team. So it was just one sort of factor that made it less plausible.
He later says it goes with his clothes.
Another potentially innocent explanation, but...
But you're saying him not knowing the members of the team was suspicious.
Incrementally taken into account with everything present here, it became more suspicious rather than less so.
Let me ask you this. I want to try to break apart the different elements here. If there was no bulge, no reasonable suspicion?
If there was no bulge in this case, this would be a different case entirely.
No reasonable suspicion. And if there was only a bulge, reasonable suspicion?
In a complete vacuum, he never encountered the individual before. I think we'd need some information about I would say this, if it was a completely blank landscape, but for I happened by a person who had on their hip something that bulged out in the manner a concealed firearm might be, my question is that person a juvenile or an adult? Because we know that carrying a concealed firearm isn't necessarily a crime.
That's not what I'm asking. Another 15-year-old, every 15-year-old with a bulge, can they be stopped and frisked?
No, in a complete vacuum, no.
So what is necessary to get this bulge up to the level of reasonable suspicion? If the bulge itself doesn't do it, you have walking away, right?
Yes.
Okay, so we know from Warren.
I do want to continue with Your Honor, but if I can step back and just clarify my earlier point. I do think that if a trained gang unit investigator encounters a juvenile who appears to display a concealed firearm in their hip.
What does that mean? Does that mean a bulge?
A bulge consistent with a concealed firearm.
This bulge, a bulge above and below the waistline that doesn't have the shape of a gun, where the only thing that makes it more consistent with a gun than anything else is above and below the waistline.
Respectfully, Your Honor, there's no testimony that it didn't have the shape of a gun.
Is there any testimony that it did?
The officer testified that based on the appearance of it, he believed it to be a firearm, and that
Is that what he says? I don't think that's what he says.
I believe that appears in the transcript in the area of 26 to 27.
He says, so I'm walking, I could see a bulge on his right side protruding from his waistline, like on his hip. He continues walking at some point. Because that's part of the characteristics of a person who's carrying an unlawful firearm. That bulge to me shows that there's a possible firearm right there. It's something to pay attention to.
Every bulge, I guess, at least that goes above and below the waistline?
That's not consistent with being a cell phone. That's not consistent with being a water bottle.
He didn't say it wasn't consistent with being a water bottle. He said usually people carry a water bottle in their back pocket. I take that to mean, well, it could have been a water bottle, but I don't think that's where people carry it, on their hip.
So what more is needed? In this case, the facts that present themselves. Prior knowledge of the juvenile, prior knowledge of his...
Prior knowledge of the juvenile? That can't be enough.
Respectfully, Your Honor, it's...
Knowing the kid?
It's the totality of the information known to the officer.
Okay,
that
please go through
carries
it
the
with
day.
me. I'm trying to figure out where we get to enough for reasonable suspicion.
Wasn't the prior knowledge of him is that he was unarmed, nice kid?
No criminal record, never had a gun.
And tonight was different.
What was the difference? Other than he had a bulge and he walked away. Other
So
than those two things, what was the difference?
And respectfully, there was a volume of things, but we're stopping at We are engaging today in the type of piecemeal evaluation of factors that my brother did in his brief, but we know that the factors must be considered in harmony with each other if they are harmonious and if they incrementally raise their value or significance.
No one's saying not to add them together. We are adding them together. We're not looking at each one individually, but I'm trying to figure out which ones are suspicious and which ones we can rely on. I'm uncertain that we can rely on walking away because we have the Warren case saying that when a young black male avoids the police in Boston, given the history of the Boston police, like if there isn't already reasonable suspicion, that can't do it. At least I think that's what it says.
We're talking in that case about people who present with no other information that is relevant to the reasonable suspicion calculus.
All right. Okay. Well, they do walk away from the police.
But without anything more. So I'm in agreement with Your Honor that is Warren's, that's the point of view from Warren. But it's.
So you think Warren says, if you've got a bulge, it could be a water bottle? Because I don't think that the police are going to pick up kids with bulges on their waist all the time or everywhere. That just seems incredibly unlikely to me. And I wouldn't like to be stopped because of a bulge under my clothing because it's on my hip. That just doesn't seem like enough to me. Now, if this person had been arrested for firearms offenses, we have lots of cases like that. Do you see what I mean? Like, if there was a particular reason to think, oh, this kid might have a gun, okay. But I'm just having a hard time seeing what says he might have a gun. He never had one before.
So it's the juvenile's proximity to firearms and gang activity. It's his location in this particular area. It's his markedly different demeanor. It's his presence with a companion with whom he was on an earlier date when a firearm was recovered. And on both of these dates, both of these young men on this particular night were behaving differently than those prior interactions. And as Justice Singh pointed out earlier, this court, I think, can infer from the facts found by the judge, it's a reasonable inference that the juvenile was creating a diversion to attract the officer's attention. The juvenile's companion, was creating a diversion to detract the officer's attention from the juvenile who was attempting to leave.
Who created the diversion?
His companion, identified by the last name of Sims in the brief.
Who yelled to this officer's partner?
Yes, as the officers approached the group. It's a reasonable inference, given that it's markedly different behavior, I would submit,
okay,
and that it coincides with the other juvenile's effort to depart.
So what we have here is 9 o'clock in the evening on a summer night, 6 kids hanging out behind the building, some adults, some younger, drinking, smoking cigarettes. The officer walks back there, and 2 of them walk away, and then the juvenile begins to walk away. And he sees a bulge, and he stops and passes him immediately. What more do we have?
We have the fact that the juvenile, in the past 2 months leading up to this night, was interacting with police officers where firearms were recovered. 2 times.
2 times?
2 times that he interacted with police officers.
Hold on. Does the record talk about both of those times or just one of those times?
It talks about the firearms being recovered on both of those occasions, and the juvenile's demeanor specifically in one, and then a generalized statement about the juvenile's demeanor that could be attributed to either event.
If he'd been cordial once, would walking away be suspicious?
It would have potentially less significance to the officer, but it is not necessarily one that should be dismissed out of hand, given other things that are present.
He has the right to walk away. He has the right to walk away, stay, say nothing, stay, be cordial. That's all of our right when police approach us, right?
Yes.
To have the right to choose what to do, I'm just having a hard time figuring out when you've done something so much that you no longer have the right to walk away without it being suspicious.
So I would say that the evasiveness to characterize it as evasive or consciousness of some guilt or a desire to avoid police,
Well, keep in mind Warren, but yes.
I will also tie it to the bulge that he has, because these things are happening at the same time. I will tie it also to the fact that he's again wearing gang-related insignia, and that's relevant to the specific area and to his past associations or companionship of people who are gang affiliated, that he's been present with the recovery of firearms, that when his companions were arrested for firearms, he maintained a calm demeanor. There were no bulges apparent on his person at this time. This time, there's a bulge.
How do we
This
know
time,
that? How do we know that? How do we know there were no bulges apparent on this?
I believe that's in the testimony, that there was nothing, nothing suggestive of criminal activity by this juvenile on that particular, those prior encounters, but for his association with, his presence in the company of people who were engaged in criminal activity, that criminal activity being a firearm. I will say also that we're talking about, again, a juvenile. And when there's the appearance of what may be an unlawful firearm, that does not sit on the same standard as an adult person with what might be a concealed firearm. So that's another factor in the consideration that elevates reasonable suspicion of unlawful possession.
Does he begin to follow him before or after he sees the bulge?
After he sees the bulge.
After?
Yes.
Can I ask you this? I know your time is up. Why do you say it has to be an illegal firearm? Let's say I'm a cop and I see a guy and I have reasonable suspicion that he committed a crime. Could be anything. Jaywalking is a crime, whatever. Open bottle is a crime. So I go up to him and I see he has a gun, or I see something that looks like it could be a gun. Why am I safe because he has a license for it? It seems like that's a dangerous situation for a cop, and I don't know why you limit dangerousness to an illegal gun rather than any gun.
Cases that have examined whether a person suspected of carrying a firearm can be pat frisked, I would say divide into two lines of analysis. If there is a person with a possible concealed firearm, that in and of itself isn't evidence of criminal activity.
And therefore you can't even stop them. Right,
In the absence of...
So I get that. If they're just walking away, you can't. But if you can stop them for some reason, and now they're standing right next to you, maybe being arrested, which people don't like, and they have a gun, even if they've got a license, I don't understand why you can't pat frisk them and remove it, licensed or not, so that he doesn't shoot you.
I think that's it can be a very reasonable approach to continuing that encounter in a manner that protects everyone.
Yeah, that's what I'm saying.
And
But it
doesn't
seemed
intrude
like
on
in
the
your brief you were
privacy.
saying because the legislature said kids can't have guns, that's why he might be dangerous. I would think anyone with a gun.
What I mean to say is that in circumstances such as that, the court has required something more, something to suggest that they are dangerous or have displayed some inclination, some behavior that contributes to the reasonability of fear of safety, whereas an unlawful firearm, the court has said, is presumptively dangerous in this context. That's evident, I believe, in the SJC's decision in Karen K, in DePisa, and as I will submit today, a 16L for the Gorado 1 decision, where the SJC does say as much, that if an officer has reasonable suspicion that a person is carrying an illegal firearm, that's a sufficient basis on which to conclude they're armed and dangerous.
No, I get it might be sufficient.
So I don't see where he observed the bulge before he started following the defendant. I don't see that. In fact, I see on
That's
24 of the hearing.
I would point to transcript 66 and 6970.
What page?
66 as well as 69 to 70.
So on page 24, he says, so you said he turned around and started walking away. He distanced himself from the group. What happened next? So as his friend was sitting there yelling at one of my partners, I just continued to walk behind Mr. Navarro's just to make further observations on why he's leaving the group. And at any point when you were making those observations, did you yell stop or anything like that? No, I did not. And then what did you see? I saw a bulge. So I don't see where he saw the bulge and then started following him. So you say page 66?
Yes.
So that's different than that testimony right there, but let's see.
Well, I think it's clarification. I think there was clarification about the timeline of when the juvenile turned and when the
first time I
officer
saw the
first
bulge was when he had turned around and began to walk away, is what 66 says. That's consistent with his prior testimony.
And there's testimony that he didn't begin to follow the juvenile until the juvenile was walking away. So if it's not as express, though I believe that it is, I just can't pin the site for your honors at this time in the transcript. If it's not expressed as that, read together, the clarification provided from the officer is that he didn't see the bulge. The very first time he did was when, on approach of the group, he saw it at that time as the juvenile saw him, turned to leave and revealed it in the process of doing so. And it was at that time that the officer followed him in the parking lot.
Not before he started to walk away, but as he started to walk away.
As he turned to walk away, but before the officer began to follow him specifically. It was upon the officer's approach of the group, the juvenile's apparent recognition of the officer, and his turn to walk away with the bulge revealed.
But he
Then the
said he
officer
was
followed him.
following to figure out why he walked away, not to investigate further the bulge.
And to continue to observe the bulge. That was his testimony as well.
All right. Your time is well expired. It's a very interesting case, obviously, to us. Excellent argument by
Thank
you.
you.
And by you.
Thank you,
And
Your
the
Honor, for your
case
time.
is submitted.
Nice job.
The next case is number 231385, Commonwealth versus Perard. We will hear first, when you're ready, from Attorney Osborne.
Morning, Your Honors. My name is David Osborne, and I represent the appellant in this case, Robert Perard. And I'm sure that you've read the brief, so I won't repeat all the facts, but I'd like to focus on the intentionality of the misrepresentation by the juror in this case. The Commonwealth concedes that there was a misrepresentation, and the judge whose findings are at the heart of this case also accepts that. The Commonwealth also concedes that that the misrepresentation was material. There is an issue about whether Mr. Perard was prejudiced by the misrepresentation, and I would like to defer that. Perhaps we don't even get to that point because the SJC is actually addressing the exact same issues that Mr. Perard has raised in this case. The SJC will be hearing argument. It looks like they're trying to schedule a November argument in the case called Commonwealth versus Marquise Mitchell, and Mr. Mitchell raises essentially identical issues about prejudice that Mr.
They've
Perard has
granted
raised.
FAR. We had that here, right?
That's in the. I'm sorry. Pardon.
We had that case here in the appeals court, did we not?
No, it's in this. It's in the
different
Supreme
Mitchell.
Judicial Court.
It went directly. It's direct appellate review?
No, it was actually decided by the appeals court. Justice Henry dissented. And it was accepted
So
for
we had
FAR.
it here, and then they
It was
have
here,
taken
and
FAR.
then it went to.
So that opinion is vacated by their grant of FAR. That is our court's opinion.
That's correct.
And they've not yet scheduled argument.
I checked yesterday, and it looks like they're asking for dates in November at this point.
Is your client incarcerated?
He is.
So if we were to defer deciding the case until they argue it, he'd be in jail a longer time.
That's correct, Your Honor. And I do have some suggestions on how to address this, although as we request in our appeal, I think you can decide this case under the current law without without waiting for the Supreme Judicial Court's clarification or whatever it may do in the Mitchell case, although I would
Question presented there is about prejudice versus structural error, or it's about...
It's the question...
It can't be about the same finding of fact, obviously.
No, it's not, Your Honor. It's what happened in the Mitchell case is the majority decided that Mr. Mitchell, the misrepresentation by the juror was not intentional, that she believed it wasn't relevant. And the majority didn't go any further than that. Justice Henry found that there was, in fact, an intentional misrepresentation, and that there would have been a for-cause challenge to the juror based on that information. She also says that...
Let me stop you there for 1 second.
I'm sorry.
Just because there's a challenge for cause doesn't mean they're going to be excused for cause, right?
Well, if there's a... Well, under Amaral, which is the...
Just because there's a challenge for cause does not mean that they're necessarily going to be excused for cause.
Right, but if there is a... We don't know what the judge would have done. These would be hypothetical facts, right? But what Amaral says, which is sort of the basis for all law in Massachusetts on juror misconduct, what Amaral says is that, based on McDonough, a Supreme Court case, U.S. Supreme Court case, says that if this would have given grounds for a challenge for cause. So we don't know, of course, how the judge would have ruled in that particular instance, but if there's a basis for it, if there's a ground for it, there's a meritorious argument for it.
Okay, so do you agree that just by having an occupation as a law enforcement officer is not enough to
Absolutely.
challenge for cause?
I absolutely do, Your Honor, and that's
Okay, hang on. All right, so just because somebody works for the police department doesn't mean that they can't be a juror in a case where the police are going to testify.
That's absolutely right.
However, somebody might make a challenge for cause, right, raising that issue.
Well, they could, but they wouldn't succeed.
So that's why I led with, just because there's a challenge for cause does not mean they're going to actually be excused
I agree.
for cause. All right? Okay. So in this case, let's assume there was a challenge for cause.
Right.
And then the judge, as kind of Judge Deborah Squires-Lee did with the Fiddler hearing, had an extensive hearing about this witness. Why did you answer your way? And determined that, no, I'm not going to excuse this person for cause. Isn't that fatal to your case?
No. Well, we don't, that's a hypothetical. We don't know how Judge Donatelli would have ruled on a challenge for cause if it wasn't just based on the fact that the juror worked for the police department, which of course is not grounds to strike a juror. That's clear under Massachusetts law. But what would make it grounds to strike the juror for cause would be the fact that she lied on her juror questionnaire. She lied during her voir dire.
She explained that she didn't think I was working for the police department. I know I worked in the police building. I know I was sworn in as a special police officer, I think I read.
Yeah.
However, I still thought I was an administrative assistant who was assigned to the police department, as I'm an administrative assistant now assigned to the fire department.
Right.
It doesn't make her any more of a fireman.
I'm glad you brought that up, Your Honor, because I do want to get into this, because basically the question of prejudice really does turn, in this case, on these facts, on whether or not the juror intentionally lied. And in this case, I think the facts are absolutely clear that she did, and I want to talk about that a little bit, because typically you would have to defer to a judge when a juror gets up there and testifies, and the judge doesn't know whether the juror is, or a witness is.
I excuse me for interrupting you, but I know you want to talk about it.
Okay.
But let's just stay focused on it, because I know you have a litany of things where she signed the document, where she goes to the police station, where she was sworn, that all suggest that the reasonable answer would have been, I've worked for law enforcement in the past. So I get that.
Okay.
So let's move from there to what's next.
I'm sorry, pardon?
So what's next?
What's next? Well, what's next is not only would a reasonable person have known that she worked for the police department, but she actually made multiple statements. We know her state of mind two ways. First of all, we know that when she first came into the...
You think she was lying to get on the jury?
I don't know, Your Honor. We didn't get an opportunity to delve into the juror's motive, because that's one of our issues is that, and which the Commonwealth actually agreed with when we filed our motion for a new trial. The Commonwealth didn't oppose the motion. The Commonwealth said he should at least get an evidentiary hearing on the issue of bias, because the judge, I was the attorney who was handling the examination of the juror, and the judge basically said, put limits on my ability to do that. And in our motion for a new trial, we said, at the very least, we should be able to examine the juror on the question of bias. So we never really got there, but it doesn't have to be, but there is case law that says that even an intentional misrepresentation alone is enough to keep a juror off.
Why are we saying it's intentional when the judge specifically found that it wasn't intentional?
Your Honor, because the judge was wrong, and I'd like to explain why. So the judge was wrong. What she said was, well, the juror, because the jurors, you have to understand, the juror completely switched once she had a motive and a means to fabricate. When she came into the courtroom and the judge examined her on the first day, she had no idea why she was there. And when she was asked this question by the judge, was there a time when you worked exclusively for the Seekonk Police Department? She didn't hedge. She didn't say, well, I don't know. I think I may have worked for the town, or I never worked for the police department. I worked at the police department. There was no hedging. She said, that's correct. Yes. So, and that's what she said when she didn't know why she was being asked the question. The judge at that point realizes there's a problem, that this is not how she answered her juror questionnaire or the question that was asked of her of the voir dire panel, of the jury venere. So the judge realizes there's a problem and then says, hey, you know, this is a crime. If you're not telling the truth, I'll give you a lawyer. She gets a lawyer. She goes off. The lawyer comes back and says, she has no Fifth Amendment privilege, Your Honor. He says, she waived it.
Answering question, so it's waived. I get it. So go ahead.
Okay. So she comes back. 12 days later, she has a motive to lie. She has my memorandum with 131 questions that the judge had asked me to propose for her examination. She's fully equipped. And at this point, she completely flips her answer. And she says, I didn't work for the police department. I worked for the town. And she comes up with this rather preposterous story about how she worked. She picked up trash by the side of the road.
We have to find that what she said, I'm not saying we won't or will, and we haven't deliberated about it, and I don't know what the answer is. We do have to find that it was clear error to believe her testimony at the second hearing.
That's the standard, yes. You're correct, Your Honor. And the reason why this is a case where you can find clear error, you should find clear error, is that we know the juror was capable of understanding the question, did understand the question, and in her mind, she knew that she worked for the police department. And then she turns around 12 days later, with all this, armed with advice of counsel, she comes up with this extraordinarily lawyerly answer, which was, I worked at the police department, I didn't work for the police department. The problem with that, in which this is what the judge ignored, and this is my concern about the judge's ruling. The judge just said, she reconsidered. On further consideration, she realized that answer wasn't right. But there's no testimony here that she reconsidered her initial answer. She just said, I didn't work for the police department. She just came up with a completely different story, which was refuted by evidence, undisputed evidence, documentary evidence that she knew she worked for the police department. She considered herself a police department employee.
Was it the second hearing at which she tried to deny working within the police department? I worked at a building.
Yeah.
The building has the fire department.
Yeah.
It could be anything. And then eventually she has to admit, I sat outside the door of the chief of police in the police department part of the building. That's in the second hearing?
Yes. The first hearing, we didn't get into that. The judge was just established that she was a deliberating juror, that she did work for the police department. And then the hearing got shut down after, for scheduling reasons. So that's why we put it off for 12 days. The judge allowed me for the next hearing to do the examination. And frankly, Your Honor, I expected the answer was going to be, I was confused by the question. That's what you would expect a juror who, didn't want to get hung up on with an untruthful statement would say, oh, I misread the question, I read it too fast. Juror didn't do that. And if she had, I would be in a very different place. It would be much more difficult for me. But instead, she came up with a preposterous story about how she'd worked for did all these different things. The town was an umbrella, she said. And I picked up trash by the side of the road, and I processed dog licenses.
Well, she said she could pick up trash. Of course, I have no idea if the town can order the chief of police's executive assistant Thursday afternoon to go pick up trash.
I can promise you that did not happen because at the time of this hearing, there had been no motion for a new trial filed. And so I did further, this was just to find out whether I had a colorable basis for one. So I did further investigation, and as you understand from the records, I confirmed that she never did that. She was paid right out of the police department budget, 40 hours a week for over 3 years. She didn't, and if she had worked for the Department of Public Works.
And that, you found that after the second hearing?
I found that out after the second.
But it's in the record. You submitted it to the judge.
It's in the record. The judge, I submitted an extensive, I submitted this as our appendix to the motion for a new trial. And the judge did not give me an evidentiary hearing, which I had requested, but she said that she would admit this into the record with no limitation, so.
And so the judge considered all of that, right?
Pardon?
The judge considered all of that in making her decision.
Well, I don't know, Your Honor, because if you read her opinion, she does two things. First, she says, well, I believe the juror was honest, and she makes no reference to anything that I submitted. Nothing, not a single piece of evidence about that I submitted to the court that was admitted into the record that refuted the juror's claim that she didn't work for a department where she clearly worked and where she represented herself repeatedly in LinkedIn pages, in her professional resume, in correspondence with the police department and the police chief. I'm so excited to be working for the police department. This is the language of the questionnaire that where she denied working for the police department. And the judge gave...
I understand, but the judge considered all of that, right?
Your Honor, I don't know that she did, because even though it's in the appendix, the judge doesn't reference anything. I think she says, oh, I considered it, but she makes no findings with regard to anything in that appendix. So for the judge to simply say, I believe her, without explaining why, except, well, on further reconsideration, she realized her first answers were wrong, but there's nothing in the record.
Why doesn't this add up to reasonable minds might differ?
Because this is not a case where, somebody says, oh, I saw something, I saw a car run through a red light. A witness says that. And, you might say, watching that witness, you might say, oh, I believe her. And somebody else might say, oh, I thought she was very evasive on that, and I don't believe her. That's fair, Your Honor, if that was the only evidence we had. The problem is that in the juror's own words, we know that she didn't see the equivalent of seeing the car run through the red light. Because she says repeatedly, I work for the police department. So you have it's strange credulity.
Doesn't she say, when the question was posed to me, I understood it to mean, am I a law enforcement officer? Do I carry a badge and a gun?
Well, no.
And because I don't carry a badge, in my mind, that's how I interpreted and that's how I received that question. Yeah. And doesn't the judge credit that?
Well, she does say that, but there's two inconsistent things. First, the juror says, well, I work for the town, I didn't work for the police department, even though, of course, she worked for the police department, and everyone understood that. But then she also says at one point, she says, oh, I didn't carry a gun or have a badge. She says that. It's sort of a throwaway. And when I asked her, well, does the question ask you if you're a police officer? She said, no. It asks if I worked for the police department, and I did not. So the juror doesn't even really believe that that's the reason. She's trying to argue that the reason she answered the question that way is because she worked for the town, she didn't work for the police department. I mean, this is like, President Clinton, arguing about the meaning of is. This is a lawyer's answer. And
that may be true. She was appointed a lawyer. I mean, she didn't ask
But-
for the lawyer. I mean, of course.
Yeah,
So,
yeah,
with
but-
that being said, I mean,
but you're-
most times when I see these cases, it's people who want to get off the jury. They're not trying to get on it.
Well, I would, Your Honor, I would, if you would send this back so that I could have an evidentiary hearing and inquire into the reason for what I say is a clear misrepresentation about something that any juror could have answered. Do you work for the police department? Do you work for a law enforcement agency? Yeah, of course. Would we really accept that of a police officer who said, oh, I didn't have to reveal my status as a police officer because I work for the town, I get my paycheck for the town, so I didn't have to answer that. That was a truthful answer. Nobody would accept that, Your Honor. Nobody would accept that. So at the very least, I hope Your Honors will send this back with instructions to Judge Donatelli to conduct an evidentiary hearing, taking into account what the Supreme Judicial Court may say in Mitchell.
Okay, so your time has expired, but if there are more questions. Okay, thank you very much. Excellent argument. We will hear now from Attorney Nadeau.
Thank you, Your Honor. Good morning. May it please the Court, Stephen Nadeau on behalf of the Commonwealth. I agree with the defendant that obviously, and the judge, I would say in this case, that the question here was not particularly ambiguous. Obviously, there is ample evidence presented as part of the appendix in this case that certainly the juror should have answered that question in the affirmative. Obviously, she did not, and the judge found, as she was entitled to do based on the testimony of the juror, that the juror was confused about whether the question applied to her. It seems like the use of the phrase law enforcement was the source of that confusion. She thought it was...
I'm sorry, I thought worked for was the source of the confusion.
Well, both of those come into play. She indicates both of them. The confusion about the town and the confusion that this doesn't apply to me. She says...
I have to say, if it's a police officer, the idea that police officers are the only people that you're the executive assistant to the chief, and your belief is that only police officers work for the police department, that is incredible, right? I mean, that's...
It's...
Right,
certainly...
there's file clerks, there's, whatever, dispatcher, there's a million people at a police department who are not officers.
Seems, at first blush, to strain credulity.
I mean, even having reviewed it, it boggles the mind how she would have answered, no, I don't work for law enforcement. I mean, I get that, it does. I mean, the questions seem clear, they don't seem ambiguous at all. This is a person who has a level of education that we'd expect to understand this language. It's not complex language. It's a head scratcher as to why she would have said no. And I think she acknowledges that. She says, I don't know why I answered the question that way the first time, right?
And then she says, if I was mistaken, I apologize, it was not intentional. And then I sort of read it differently than my brother. I think the second hearing, rather than a completely different tack, she's saying, well, no, if I think I was right about that. She was wrong.
It's a little more definitive than that, right? She comes out of the box. It was right then and it's right now. And she doesn't say, on reflect, but okay, go ahead.
Yeah, I'm comparing to the first day when she says, I'm sorry if I was wrong. And then the second day, actually, I think I was right. She was wrong, obviously.
But since everyone agrees, including the judge, that she was wrong in how she answered it, does the whole thing hinge on her intent?
Yeah, I believe so. I believe
There's no other way to look at this issue. It all hinges on a finding that she intentionally misrepresented?
Yes, that's how I read it. I don't see that there's, for instance, like a negligence standard. Would a reasonable person in her position have understood? What was her actual intent? Was there a demonstration of actual bias? I refer to the Mitchell case, which the SJC has. There, the issue is whether the juror having knowingly omitted information that she knew was responsive to the question, whether they could credit that the motive there was not an improper one.
So we could look at this record and see if there's sufficient evidence to to allow someone to infer that intent. It's not, maybe it's not simply deferring to the judge's credibility determination.
Well, that I don't know. Credibility classically sort of being a question for the fact finder who's there to see the witness. I do recall there was an exchange on the second day of the hearing where there was a disagreement between counsel and the judge. She's not being straight with her answers, and it was like, I think she is being straight, and that's sort of a call the judge gets to make. I also, in Amaral, I believe it's page 628, they indicate once the motion judge becomes convinced of the essential truth of what the juror is saying, sort of the need for further inquiry dissipates at that point. So it does.
But maybe what Justice Singh is saying is we don't defer to credibility judgments when we're reviewing documentary evidence. And maybe the documentary evidence demonstrates the intent.
I don't know that it demonstrates the intent. Again, I think, and it hinges on that section. Clearly, she knew she worked for the police department, at the police department, does not bear on the confusion or misapprehension that day about, again, the question about law enforcement based on her own description of it. That's not something that was supplied by the judge in this case. That was the testimony from the juror that was based on.
So the judge says that notwithstanding, based on the testimony in the appendix documents, which seems to include all of the many instances where she acknowledged working for police and being sworn in and all of those things, she says that, I credit in full the testimony of Juror 125. She fully understood and took seriously her responsibility to answer not only the questions on the questionnaire and during impanelment, but also the questions put to her during this two-day hearing. She was candid and credible in explaining what this court finds to have been a misunderstanding of the scope and meaning of the questions related to law enforcement employment. I find that she truly considered herself to be a town employee assigned as an administrative assistant to the police chief, and that she honestly interpreted law enforcement for purposes of the question to mean those who wear a uniform and badge, carry a gun, and are engaged in actual police work. So how do we get around that?
Which part? I'm sorry.
That finding, how are we to say, okay, Judge, you found that, but we're rejecting it?
Well, I think...
I mean,
that's
it seems what we're being asked to do, right?
I think to flip it, you would have to get around that finding.
Exactly.
So I think the judge made an appropriate call based on the testimony before her and the credibility of the juror that was questioned on 2 days, subjected to cross-examination. I don't think...
Do we give any deference to the judge's findings?
Yes. Yes, absolutely. And I think at a certain point, some of the evidence becomes cumulative. Yes, clearly she was mistaken. Yes, obviously she should have answered this correctly. But here she has been for 2 days under questioning from me, under cross-examining from counsel, and I believe her. And the judge is entitled to make that finding. And under Amaral, essentially once the judge has accepted that, the inquiry as to actual bias terminates.
So you would, the Commonwealth had taken the position that on the motion, that the defendant had raised a substantial issue, so sufficient for an evidentiary hearing.
Yes, yes, and certainly that was, given these circumstances, we wanted to allow the court and the defendant to, develop as full a record as possible. The judge, having heard again from the witness, or the juror rather, under oath, decided, again, no, I believe her, and I think that goes into the Amaral point of the need for further hearings, further evidence dissipates. Whereas, again, yes, I accept that she should have answered yes, but she was mistaken.
Is your position today that there's no purpose for an evidentiary hearing under the circumstances?
In these circumstances, there would be, I think the judge was within her discretion to find, then what would further hearing accomplish? It would be cumulative cross-examination on the same subject to establish what basically everyone agrees that she should have answered.
But wait, I thought the hearing would be about bias.
I think in light of any of that stuff, but the inquiry to bias ends once the judge had found that...
Wait, so it doesn't matter if a juror is biased so long as they answered all the questions, even if they answered them incorrectly, mistakenly. We no longer care about bias?
That is, as I understand it, it would have to be relevant to the showing of bias, and if she was honestly mistaken, where does the bias come from?
I see.
I'm sorry?
No, I see. Let me ask you this. She said that she referred to herself as an employee of the town. And then she's cross-examined with like 6 documents where in fact she refers to herself as part of the police department. Would it have been clearly erroneous for the judge to find she referred to herself as working for the town?
No, I don't think so. And I think that part of the evidence, too, was that at the time of trial in 2019 was the transition point between the police department.
The question was, at the time when she was working for the police, did she refer to herself as working for the police? And she says, I don't remember exactly how it went, but she says, no, I always referred to myself as working for the town. And then there's 6 documents where she clearly refers to herself as at least part of the police department without mentioning the town at all.
And so I acknowledge, of course, that does...
Okay, because I'm just trying to figure out, occasionally courts do find judicial findings of fact to be clear error. And I'm just trying to figure out if you're saying so long as she utters the words and the judge believes them, the judge can ignore all the documentary evidence.
I don't know that I would go so far as to say in all case, for instance, as a matter of law, that this court could never find. But I think, again, here it goes, again, all to the same sort of cumulative issue, and directly testified to by the juror, her own lack of intent, her own misunderstanding, and so the judge based it on that, subject to cross-examination.
Had the juror answered, I'm going to say truthfully, that she worked for law enforcement, let's assume for the sake of discussion that that's the truthful answer to the question, notwithstanding any misunderstanding, would Mr. Perard have had a valid challenge for cause?
I don't think so. Clearly based on, it might have, and I know the
so if she had
language
said,
is that there's a challenge.
I work for the police department, I've been working for the police department, I'm a special police officer, you don't think that's a valid challenge for cause?
For cause, no. Her status as an employee, where I think the law is clear that even status as a police officer or a corrections officer does not disqualify you.
So now we find out that that's not a truthful answer. Do you think that that's a valid challenge for cause? If in the course of the impanelment, now we find out that she answers the way she did against the appendix of information, would that have been a valid challenge for cause?
Perhaps, but I think it depends. Did she know? Was it intentional? If not, had it been sorted out at voir dire that she was wrong, she'd be like, oh, I'm sorry.
You don't think if there was a new trial and somehow she's on the jury again?
I think that would be implied bias.
And the defendant says, I want to strike her for cause. Here's my appendix about what she said the last time. You don't think the judge would be like, yeah, of course she's struck for cause?
For all the reasons that, of course, she would, yes.
Yeah.
But I do think, again, with the finding here is that she's a juror on a case, and you answered the question mistakenly but inaccurately, that would not imply or give rise to actual bias. So she could serve on a jury, again, based on the finding here that it wasn't intentional, there was no intent to deceive, there was no adequate showing of actual bias or of implicit bias in this case.
If it was revealed that she answered inaccurately, that could have been explored further for bias.
Yeah, yes, but I think, and again, didn't come out in time for the trial, obviously, but that was explored here and found that there was no actual bias, again, based on questioning of the juror herself.
And so the case law tells us that we're constrained by the challenge for cause. As a matter of fundamental fairness, don't you think that the defendant would have struck this juror if they had a peremptory given this information? Wouldn't they? This juror would not be on that jury.
I believe it's in Amaral where they discuss that essentially if a challenge, that the present challenge is one to the fundamental fairness of the jury, which is constitutional in nature, if that is not shown, the deprivation of the right or the statutory right to a peremptory challenge cannot entitle you to relief where it's not based in the Constitution. If there are no further questions, I'll leave it there.
There are no further questions? All right. Thank you very much. Excellent arguments from both of you. It's a very, very interesting and unusual case. So thank you. Our next matter is number 23477. I'm informed that it's partially impounded, but that doesn't cover the name of the defendant, does it? Okay, so this is Commonwealth versus Mack. And we will hear first from Attorney Ramos.
Good morning, Your Honors. Melissa Ramos for Mr. Mack. May it please the Court. I do hope to get to address both issues this morning. So first, I'll start on the insufficiency argument. And the Commonwealth failed to prove the terms of the restraining order here beyond a reasonable doubt. Specifically, they failed to prove that there was a stay-away provision of any order. And this impacted 2 of the 3 charges of conviction, the assault and battery on a person with a restraining order and the violation of the restraining order. And regardless of the Commonwealth's ability to prove the defendant's knowledge of any order, they were still required to prove the terms beyond a reasonable doubt, because for both charges, the jury was specifically instructed that they were to determine whether an order issued which required the defendant to stay away from the witness beyond a reasonable doubt. And on this record, the jury would have had to stack inference upon inference and speculate regarding the terms of the order, because the biggest issue with the witness's testimony is that there's no distinction between any order that was in place from October of 20 to October of 2021, and any order that may have been extended past October 2021, given that the events at issue were in February of 2022. And so the terms of the extension are key here, and there's no testimony regarding the terms of the extension.
Doesn't the victim specifically talk about that?
So the victim does not make any mention of the terms on direct examination. And so the only thing that eventually comes out on cross-examination where the victim does say we were both fully aware that he couldn't have contact with me are not grounded in space or time. So there's no connection to that knowledge to the time frame that we're dealing with here of February 2022, because given her testimony in its entirety, she is emphatic that she doesn't know anything about an extension. She was never included in the process.
The defendant told her the terms.
And again, those statements are not grounded in time. So they may have known about any terms from the initial order that was put in place for 1 year, but there's nothing to connect those to the order by February of 2022. She never saw an order. She was never involved in an extension. And given that there was a change in circumstances, that she had had the baby by this point, it's not a foregone conclusion that any extension order would have prevented them from having contact. It could have, the terms of the order could have changed to allow them to co-parent. She only claims that she got information directly from the court in the middle of that first year order that she had asked for.
Wasn't there testimony to the effect that she wanted to actually change the order and then she was advised that she could not do anything? So the terms of the order that were there to begin with continued?
Only as far as we know for the first year, because when she calls, that's in the middle of that first year. And as we know under Massachusetts law, in any extension order, terms can change. And so again, given that there's a change in circumstances with the baby, we have no information about what happened with the extension. And none of the statements made by any witnesses were concrete enough to tie terms of an order to that time.
Even though she may not have, even though her testimony was, I couldn't do anything about it in New York, they told me I couldn't change it. You're saying there could possibly be some circumstance that in some other way it was changed.
Absolutely, because even her testimony regarding kind of the process of this order is not something that necessarily comports with Massachusetts law. So there's really no information about how, this order, the life of this order, what happens to it. And so given that there must be an extension in October of 2021 for it to be active in February of 2022, there could have been some change at that time. And there's no testimony regarding what was in place in February of 2022.
But you agree that there was evidence that it was active at that time, just not what the terms were.
Certainly. There's evidence that it was active and, defense counsel wasn't challenging the existence of the order. But that did not, relieve the Commonwealth of their duty to prove the terms of the order beyond a reasonable doubt. Even in the light most favorable to the Commonwealth here, where there's two equal propositions, neither of them have been proven beyond a reasonable doubt. And here
Can we speculate that? I'm trying to figure out how are we to look at the record. What we have is she says, I was told that I couldn't change it at all, and it was a no contact order. But there's nothing that sort of, are we allowed to assume that maybe it changed without anything else in the record that suggests that it changed?
Just as we may not be able to assume that it changed, we can't assume that it stayed the same either, because there's this fundamental change.
Why isn't that why isn't that the proper way to look at it? That in the absence of any information that it changed, it stayed the same.
Because the nature of an extension order and the changed circumstances could have changed the order fundamentally. And so it's the Commonwealth's burden to show that the terms that the jury is instructed to find are connected in time to the active restraining order. And here all of the testimony is too vague to connect it to whatever was active on February of 2022.
Didn't the defendant at some point say that the victim holds it over his head?
So the defendant does make statements, and those statements don't add much to the Commonwealth's case. I submit that they're vague, they're not grounded in time, and he did say that he thought the order was unfair, and he can think it's unfair for any number of reasons given the nature of their relationship.
But he said that she holds it over his head. She threatens him with invoking it.
Yes, and again, those are not
So
grounded in
there
time.
has to be some kind of violation going on, or that would be an empty threat.
It's possible that there's some kind of violation going on, but we also don't have those statements grounded in time either. So all we know is that the witness is actively engaging.
When does the defendant say that?
He says it during his interview after he's arrested.
After his arrest, and he uses the present tense.
Yes.
He doesn't say she held it over my head for a long time, or she holds it over my head, right?
Yes. That statement is still too vague and not grounded in the time of what's going on in February of 2022, given that they have an active relationship where they're engaging in communication, where the witness is actively reaching out. at points in time that are after the October 2021 extension. So given the nature of all of the testimony, it does not rise to the level of beyond a reasonable doubt that those were the terms of the order.
Why do you say that?
Because we know that she only knows the circumstances of the original one-year order.
Throughout the course of the restraining order, did they interact with each other?
Yes.
From the first year
Yes.
and beyond?
Yes. During the first year, she goes back to New York to visit on at least 2 occasions before the expiration of the order.
And at that time, he's fully aware of the restraining order, and he knows that she's initiating contact, and he engages in contact.
Possibly. There's no statements from him about what was going on during that time.
Doesn't he say, I knew I could get in trouble, I can get in trouble if I come to Massachusetts to see you? What is he referring to?
He specifically says that he was aware of an order, that he thought it was unfair because she holds it over his head. At some point, she testifies that he says...
So what does that mean?
I don't know. I don't know that it means what the terms of the order are, what it prohibits him from doing, which is the specific stay away that the jury is instructed to find if that stay away provision exists.
Are we talking about any other conduct? We're not talking about violence, right?
No. The jury instructions actually note that if the Commonwealth is moving forward on both do not abuse and stay away, that both of those should be read. So the jury was specifically only instructed on whether the order had a stay away provision. And I would say that Commonwealth v. Kirko, which I focus on in my brief, is instructive here because there's no argument about the existence of the order. It's all about the terms. But in Kirko, the jury still heard about the stipulation, even though the stipulation wasn't properly entered. And so the jury had still heard about, possibly the terms of the order. But ultimately, this court found that it was insufficient because the stipulation hadn't properly been entered. And here, there's too much, the testimony was too vague to determine that there were terms, that this term was in place in February of 2022. I'll move on to the ineffective assistance of counsel claim. And here, counsel was ineffective for failing to move to strike the witness's undisclosed statements. At sidebar, the judge found that there was a discovery violation, and the judge was inclined to give the defendant a remedy, should he have asked for one. Counsel initially properly objected, and like I said, the judge treated this as a discovery violation regardless of any comments on the motions.
The judge found there was a discovery violation?
Essentially by saying, you're the charging entity, it's assumed you know what the evidence is going to be, you have a duty to turn that over to the other side. He's talking about the defendant's statements that were never turned over.
Why isn't he talking about the past bad acts, the additional past bad acts she was testifying about?
So,
how can you tell which it is?
The conversation at sidebar, so the judge raises the motions in limine, essentially saying, given that we had this litigation on the motion in limine, you are in even more of a position, Commonwealth, to know what she was going to say because you were supposed to have instructed her.
Motion in limine is about past bad acts.
Yes, so the judge, I think, the inference from what overall what the judge is saying in the conversation back and forth is, you knew, Commonwealth, that you were supposed to instruct her not to say these things. These are the things she could not testify to given the order on the motions.
Other past bad acts.
Other past bad acts. And so in that preparation, you're supposed to, because there's a specific conversation you're supposed to have with her about her statements, you're supposed to know what she's going to testify to when you're asking her these questions about, the threats in particular. And so beyond the focus of the discovery violation, essentially what's happening at sidebar is that the judge is inclined to give some kind of remedy to the defendant should he want one.
The defense attorney was supposed to propose something.
The defense attorney did propose a curative instruction, but ultimately backed off and did not ask to strike the answer. So he essentially gives up on any possible solution, which was manifestly unreasonable. And the judge didn't sustain.
How do we know that?
Why is it manifestly unreasonable?
Why is it not tactical?
Because he was so effective in cross-examining her and impeaching her on other aspects of the charges, because the jury ultimately finds Mr. Mack not guilty of strangulation and reckless endangerment, that to not use the delayed disclosed statements to impeach her.
Wouldn't it be just, wasn't it the judge who made some reference to, think very carefully whether you want me to actually make an instruction and to draw the jury's attention further to this issue? And so,
yes,
isn't that quite likely what counsel did? Step back and realized, yes, I'm going to just let this go because I don't want to draw the jury's attention to it.
But counsel still could have moved to strike the answer. And so because it was left both unstricken and the judge did not sustain the objection on the record, it was just fully there for the jury to consider.
Even the striking, doesn't that draw the jury's attention?
Not necessarily, because there doesn't need to be a repetition of the answer in order to strike it. You can sustain the objection on the record and just say, jurors, you're supposed to strike that last answer from your
Can we decide this without something from the attorney explaining the reasoning?
Yes, Your Honor. Given, again, the effectiveness of cross-examination and impeachment on other areas, there's additional impeachment is not cumulative. It can sway, ultimately, the credibility of the witness in front of the jury. And so there's no reason to not use it, given the way that he was effective. There was the whole issue with whether she had given pictures to the police, and he effectively used that, and ultimately the defendant was found not guilty of strangulation. So there was clearly an effective way to use these statements in cross-examination, but the best option would have been to strike it entirely, and the Commonwealth agrees that if the attorney's lack of request to strike was manifestly unreasonable, or any of the attorney's actions were manifestly unreasonable, that it did prejudice the defendant because there was only one delayed statement that was the basis for the threats charge, and so ultimately had all of those answers been stricken, as the judge would likely have been inclined to do, there would have been no basis for the threats conviction, and a required finding would have entered.
Okay, your time has expired, and I see no further questions. So thank you very much for an excellent argument. Yep. We will hear now from Attorney Cohen.
Good morning, may it please the court. Jennifer Cohen for the Commonwealth. The Commonwealth argues that there was sufficient circumstantial evidence admitted as to the restraining order for the fact finder to find in the light most favorable to the Commonwealth that the charge was supported.
The specific jury instruction that was requested regarding the restraining order, they honed in on the language of stay away. Right? There was no other provision, right? That it was the stay away provision that was violated. Okay, so can you point to us in the record where it's clear that the stay away provision remained as of the date of the violation?
Yes, Your Honor. So I would agree that throughout the testimony, the victim specifically referenced a no contact order, but I would argue that under these circumstances where the allegation is that these parties are traveling together, living in the same home together, that no contact implies no being right next to each other, living together, I suppose, and that no contact covers the stay away contact as well.
Okay, so if we accept that, how in the record is that established?
So first off, the victim does testify that she put in for a year-long restraining order. Now, I know that's not proof of anything. However, she does tell the court that she tried to contact New York to see if she could get rid of the restraining order, was told that she couldn't do anything about it and that it was a no contact. And then after that, she would get updates from the defendant about the fact that the restraining order was still in existence, with him asking if she could get rid of it. And then she did testify that when she was bringing the defendant back to Massachusetts. They didn't discuss exactly the implications or possible consequences to him of him coming to Massachusetts, but he did say, you know, I can get in trouble. I think it's implied there that he's not supposed to be with her. And then, of course...
Is he getting in trouble because he's contacting her, or is he getting in trouble because he didn't stay away?
Well, I would say, Your Honor, again, that the stay away in these circumstances is implied in the no contact. I think no contact can cover telephone calls, but I think no contact can also be no contact in person, and that's what we have here.
Why do we often have terms that include no contact and stay away?
For a situation where I think you don't want a person coming within so many feet of the victim or the plaintiff, but you also don't want them calling or texting or things like that. But I think no contact is an additional term for those reasons, so that you can't get at somebody from a distance. But I think no contact, just as a lay person, could imply no contact in person as well. And then I would also just say the defendant's admission after he's arrested, that he knows that the restraining order exists, and he says he felt it was unfair that he was asked by the plaintiff to come to Massachusetts. And I think, again, there's an implication there that he's saying she's put him in the position where he's violating the restraining order.
Can you tell us the reasoning for not there was an intentional not submitting of the restraining order? Is that because of all the other language, or?
Your Honor, it's not in the record, but I was the prosecutor at trial, so I can say we did not have the restraining order, a certified copy.
The police received it in a fax or something from New York.
I'm not sure that I received that prior.
They're part of the prosecution, so, I mean, obviously this would have been much easier.
I understand. And I will say in my defense, this was not an assigned case, so I did what I could with what I had at the time.
So given we're talking about violation of a court order, I mean, the case law, anytime we're talking about a violation of a court order, the case law requires a clear language to judge, by which you judge the defendant's conduct. So, if we start with that premise, and we have in the evidence, I guess I'm going back to the question of the victim's understanding that she could not do anything about changing the terms of the order. Can we assume then that it remained the same? Or do we look at it as it's equally possible that it changed in some other way that she has no control over?
I would argue, I think she did say that she was told it couldn't change. Notwithstanding that, I think the other evidence that you have saying that the no contact remained is the defendant's own statements, and his own statements essentially that the victim had placed him in the position that he was violating the order. I think that goes to his knowledge of what the terms of the order were.
If the terms were, did he arguably contacted her and didn't stay away, right?
Correct.
So is it a distinction without a difference? I mean, did he comply with either of those terms on these facts?
No, but I think it was clear from the testimony and I think the theory at trial that defense was trying to show that this victim was not credible because she had instigated contact with the defendant. And I think that doesn't go to the existence of the restraining order or not.
I'm surprised. I didn't realize until this argument that the judge instructed on stay away, not on no contact.
Yes.
How far away did he have to stay?
Presumably further than in the car with her. Your Honors, I have my argument, but of course I do acknowledge that there are some problems here. I do think that even if Your Honors find that in this particular case there wasn't enough to show that the restraining order existed, I think that the law still allows for a circumstance where the Commonwealth could go forward without a certified copy of the restraining order.
Of course that's true.
So in this circumstance, I would say if the court disagrees and finds that there wasn't enough to support the restraining order, that the appropriate remedy would be to remand and enter into conviction on the lesser included of assault and battery on the assault and battery in violation of a restraining order charge. The instruction was given.
It seems to me that all the evidence is about no contact. Now, I don't know.
And I realize that it's circumstantial and requires a reasonable inference, which I argue can be made here, but if the court disagrees, I think there is enough to support the lesser included of assault and battery.
Yeah, the problem is sometimes, even though the defendant says, I know I'm in trouble, a defendant could also be wrong about his own.
I agree, Your Honor, and I think that perhaps the problem here is it's not the defendant's knowledge. I think the issue is actually the existence of the restraining order itself, which my sister did not argue, but I think that is the problem. Again, I'm arguing that there was enough circumstantial evidence to support that.
And could you just turn to the second argument regarding the additional statements?
Yes, so the Commonwealth would say that this was not ineffective assistance of counsel. First of all, the difference in the victim's testimony was a variance of what was contained in the complaint and the police report. The statement at issue was discussed in the context of a motion in limine for prior bad acts, and I believe it's clear from the testimony that the crux of the problem was that everyone thought that the testimony that the victim was not supposed to give was in relation to a prior bad act. However, when she testified, she was not testifying that the threat to keep everybody in the house and light the house on fire happened previously. It happened while they were in that car during the incident. And I think because it was a variance of something that the defendant was already made aware of, because it was not a prior bad act, a motion to strike the testimony would have been unsuccessful, and so he was not ineffective on that basis. I would also argue it wasn't ineffective to fail to cross on the discrepancy between the testimony and the police report, as I think that could have highlighted the testimony. And I think failure to cross on a subject is not something that amounts to ineffective assistance.
I may have missed this, but I didn't really understand the discovery violation piece of this. Is a prosecutor supposed to know for sure what words their witness is going to use?
Well, I would argue no.
Well, I mean, we do see these cases where, I had one last year, I think, where suddenly someone said, like a first complaint case we had, where it's like all set, like this is the person who's going to testify, and then unbeknownst, apparently at least, to the prosecutor, suddenly the victim testifies like, first thing I did was call my mom and tell her. And it's like, you never said that before, and now, I mean, I don't know how you're supposed to keep someone. I mean, obviously there could be a hearing and a finding that you knew or whatever.
I would agree. I think anybody who's ever questioned a witness knows that things never go exactly according to plan, and I think that while the judge took issue about this statement and was saying that it was an undisclosed statement, I think it was something that I was not aware was going to be said, and it wasn't a discovery violation. It was in line with the complaint, and it was in line with the police report. It was a variance of what was relayed in the police report.
Do you think what concerned the judge was the additional past bad act, which doesn't have to do with the sufficiency of the evidence? Or that the statement describing the threat was different? Because it said burn down the house, not burn down the car.
It's my understanding that the judge appeared to be upset about an undisclosed statement, and that counsel was concerned about this being a prior bad act that was not supposed to come in. And so that's why I've addressed both points, because I think both were raised.
One other question on the ineffective assistance. Was the claim that the counsel should have cross-examined the victim based on what was contained in the police report?
I think the question is whether, yes, he should have asked her if she told police something different than what she testified to that day, and I think that would have underscored potentially the threat that she was saying he made now, other threats that he may have made. I think that would have been unhelpful to him, especially where he'd questioned her about another discrepancy in the police report, and her answer was something to the effect of, well, that's what the police wrote down then. I think that was the least effective of his cross, and I did list in my brief the many subjects that the defense crossed the victim on, and he was effective in crossing her on that, so I don't think that failing to cross her on this one point would have affected her defense in any way. I'll rest on my brief.
I see no further questions. Thank you very much.
Thank you very much.
Excellent argument by both of you. We will next hear number 23-1474. This is PAULHUS versus Dwiggins. And we will hear first from Attorney Tallerman.
Yes. Thank you, Your Honor. May it please the Court. Jason Tallerman, Town Council for the Town of Southborough. Your Honor, this is a case not particularly necessarily of first impression, but this is a case of first impression from the standpoint that it's the first time that this court will consider a particular application of this statutory scheme to create a bright line test, whether or not a bright line test should exist with respect to the more omnibus provisions of Chapter 140, Section 131, which relate to licenses to carry in the Commonwealth. The system is administrated in most instances in local municipalities with routine licenses to carry by the police chiefs. The statute itself has a number of subsections.
So we're talking about unsuitable, right? Is that?
We're talking about unsuitable, not the categorical.
We're talking about unsuitable.
Right.
Okay.
And
we're talking about pre-October 24, obviously.
Yes.
Right? Because the change is in October 24, I think.
Yes, but not with respect to the particular provisions under which this case arises. There has been some significant changes to the licensure statutes, but with respect, there are categorical reasons for denial of a license to carry. We don't view
Wait. No, go ahead, please.
Those are focused on the applicant, right?
Those are definitively focused on the applicant's own behavior, the conduct that a criminal offense, a felony offense, where you simply have to be denied.
Prohibited.
That's prohibited.
We're talking about unsuitable.
Unsuitable.
Okay.
Where all the other categories go, where a police chief is charged with a fairly awesome responsibility to make.
I understand, but let's just talk about what the statute says.
Right. So the statute, far from creating a bright line.
It says unsuitable if a reasonable exercise of discretion, it determines that the applicant is unsuitable based on reliable and credible information that the applicant or licensee has exhibited or engaged in behavior that suggests that if issued a license, the applicant or licensee would create a public safety.
Correct.
Is that what you're?
That's exactly the provision.
I'm sorry, when the chief made his decision, did it not also say, or existing factors that suggest that if issued a license, the applicant or licensee may create a risk to public safety?
Absolutely stated that, Your Honor.
Okay, and that's been gone since 2022, but when the chief made his decision, that was in there.
Correct.
Okay.
So are you relying on 1 or 2, or are you relying on 1 and 2?
Our case relies upon the fact that the statute doesn't contain such precise language that a licensee, a prospective licensee who is in a difficult household.
I'm asking, are we saying that the applicant was unsuitable based on reliable and credible information that the applicant or licensee has exhibited or engaged in behavior that suggests if he was given a license, he'd create public safety? Or are you saying that existing factors that suggest if he issued a license, the applicant or licensee may create a risk?
The former.
Right, you're focusing on 1.
Correct.
Right, okay.
Correct.
That's not what the trial court found. You can get rid of your best argument if you want to, but why are you not relying, as you did below, on existing factors?
Well, we think that the case law itself talks about, and we can look at DeSisto, for example, for the case law, which we do rely on, that where the trial court in...
What year is DeSisto?
What's that?
What year is that case?
The DeSisto case is... ...2021.
Okay, go ahead.
So in DeSisto, it uses the similar language where it says existing factors suggest that if issued a license, the applicant or licensee may create a risk to public safety.
So that's part 2.
It is part 2, but
That you're not relying on, or you are?
No, we read that entire language as part of the test. We don't think that's separated. They're not separate
Well, it's funny because it says or and then has another number. So it might be that you could find it one way
Right.
or the other. So they're separated in the text.
But we view them as part of the same analysis. And the cases don't suggest that they are alternative analyses.
Well, it says or, so I'm going to go with what the language says. But let me ask you this question, if I may. What reliable and credible information about the applicant that he's engaged in some behavior that suggests if issued a license, the applicant would create a risk to public safety?
We believe, well, first of all, Your Honor, the trial court found that the police chief did not act arbitrarily or unreasonable.
I understand that.
So there are 80...
He's constrained by the statute. So I'm asking you about the language here, which is, what about the applicant?
There are 80 negative police interactions with this family.
Not the family, the applicant.
Right. The applicant was involved. Now, we take I want to answer that in 2 ways. First, the applicant was directly involved in some of these. He was involved in a knife fight with his son.
Okay, so what about his behavior? What did he do in that?
So this comes to the second part of our analysis, Your Honor, where the statute isn't so precise.
Hold on, before we get to the second part, what did the applicant do when he was confronted by his son that you would suggest he somehow had a negative interaction based on his conduct?
Again, we don't
Can you answer Justice
yes.
Desmond's question,
Yes.
please?
He had to knock a knife away from his son.
So that he shouldn't have done that? What did he do to create that situation?
The statute doesn't require him to create a situation.
It says that he has exhibited or engaged in behavior that suggests that if issued the license, the applicant would create a risk to public safety.
And
so I'm asking you, what behavior did he engage in that if issued a license, he would create a risk?
We don't view our entire case, Your Honor, is based upon the notion that the pattern of conduct and behavior doesn't necessarily require that the licensee engage in nefarious behavior themselves.
It says the applicant. It doesn't say the applicant or his family. It doesn't say everybody at the address. It says the applicant.
Right.
I mean, you may be right that it doesn't have to be nefarious behavior. It could be laudable behavior, but it does say behavior exhibited or engaged in, and you don't seem to be answering that question. You don't seem to think that matters.
No, we think it does matter, Your Honor, because if they are involved in direct, unlaudable behavior, then that's a clearer case. The reason we're here before you is because the town and the police chief believe that being part of such a tumultuous household and be involved in situations even where you may try and prevent violence results...
That's his behavior.
Correct.
Being involved in that atmosphere.
Right. And we read every day, we open the newspaper every day to situations where a good person gets their gun taken from a member of their own household and causes harm. The statutory scheme...
That may be true, but that may be true. That may be true. But we're talking about this case and this applicant. And so what I'm trying to determine is what conduct that this applicant has engaged in, not his wife with mental health issues, not his 15-year-old son on the sauce. What did this applicant do? What behavior has he engaged in?
We readily concede, as the court conceded, and we have no facts, and we are not trying to paint this applicant as a ne'er-do-well in any way, shape, or form. Our entire case relies upon the notion that being part of this household so close to so much violence, mental health concerns, and drug abuse creates a situation where a chief feels that to prevent, again, the statute is perspective. The statutory scheme isn't to penalize people who did things, but it's to look into the future and see if a situation would resolve. And I would analogize...
I think that's reasonable. But isn't that an argument for the legislature? Because that's not what the statute says.
We believe that it could very well be, and I would love to see more clarity from the legislature on this very issue as someone who represents chiefs in dozens of cases a year on LTC issues. I believe it'd be a perfect example of something that the legislature should tie up. But I don't think that it's an unreasonable read of the existing statutory scheme to find in favor of the chief and overturn the court here. If we look at the Karras case, for example, where the person who lost their license did engage in laudable behavior because someone who was unlicensed did get a gun from his glove compartment, and this person reported it. And it was even reported in the case that that was great behavior, and it may have been an aberration.
What year was that case?
Karras is 2019.
2009?
2019.
Okay, so this language was in the statute.
Was the gun stored properly in the glove box?
It was in the glove box.
Is that how it was supposed to be stored? Was it
No,
locked?
but there was no...
So there's some behavior.
There's some behavior there.
There is some behavior here. I think that the lesson, though, there is, do we wait? Does a chief wait? Putting yourself in the shoes of a chief. And I understand the counter-argument here. Does a chief wait for Karras to happen? Does a chief wait for someone...
No, it's the statute.
Yes.
We don't... everyone has said what the chief did was reasonable.
Right.
Everyone has said that.
Right.
But there's a statute that dictates what the chief has to do.
Right.
And if they do something not authorized by the statute, it has to be undone.
Well, and we would submit that if they wanted to write the statute's clear. There's a number of categorical bright line tests. Then we get to this provision where it uses terms like suggest and may. We think that...
Focus on the applicant.
It doesn't specifically state that the applicant has to engage in a specific activity that is disqualifying.
It doesn't say a specific activity, but it says the conduct has to be the applicant's conduct.
But the applicant's conduct includes participation in a household where it's...
So tell me how he participated.
He is participating. He had numerous interactions, which we detail in our brief, with his son who had significant health concerns. He talks about his wife in a way of saying like, oh, don't worry about it, I could overpower her.
Okay, the son I get, right? He's gone in, maybe laudably knocked a knife away, but he was right there with someone with a deadly weapon, and maybe that's enough. To say his wife is mentally ill and may steal the gun isn't about his conduct at all. Now, he does live there, that's conduct. Deciding to stay in that house, that's conduct. But talking about what his wife does and says isn't behavior.
We believe that the statute can and should be read in this day and age, when we find on the civil side or even on the criminal side that you could be found liable for your inaction.
Well, maybe, I don't know why the legislature did this. Here's a hypothesis. The gun lobby talked to them and said, don't take people's guns away or not license them unless they engage in behavior. Their mere circumstances aren't part of it, and that's what they wrote. Now, maybe they wrote it by mistake, or maybe they meant something, some broad behavior, but it doesn't say if their wife is mentally ill, that would be unsuitability. That wouldn't be based on any conduct.
Or if the household is unstable. It doesn't say that.
It doesn't state that, but it doesn't directly preclude it either, is our point, Your Honor.
Well, the focus is on
we agree that it's focused on the applicant. Picture, if you will, hypothetical.
We know you're going to tell us something dangerous, of course.
Same knife altercation with his son. He's wearing the sidearm, which he would have the right to do within his house. We're talking about a situation that we read about every day, and if we can find that same person liable civilly or criminally for being an inactive participant in a crime, how can we handcuff, no pun intended, a chief from taking action that might be overly protective to avoid this potential situation in the future?
So where do you draw the line? Let's say that the applicant lived in an apartment building next to an apartment that routinely has gang violence, and people are coming to the apartment next door, and the police are coming to the apartment next door. And the argument is, well, if he has a gun in the house next door, they may kick in his door and get the gun. So those existing factors, those surrounding circumstances are such that nobody in that building should have a lawful gun.
Well, I don't think that we're looking for a categorical rule here. Don't forget, the test has an evidentiary check on it, which is an action, a de novo action in the district court, for which facts can be found and a chief can be found to have gone too far. This is a case-by-case analysis. That's what the cases say. We have a reasonableness test. We have an arbitrariness case. We can all design a fact pattern which stretches the facts.
Can I ask you, your time is up, but I have I think, quick question.
Sure.
Are there other kinds of licenses to carry that don't include residence? Like if he wanted to have a gun, but he was going to store it at his gun club, something like that. Is there a license that does that, or they're all residential licenses? If you can do that, you can bring it into your house.
Well, you can have a license to use a gun, to have a gun, and it's not limited to just being on your premises. You can go.
I asked you the opposite question.
Okay, then I didn't.
Is there a license for a gun that allows you to carry some places but not your residence?
I'm not aware of any, Your Honor.
Okay. Your time has expired. Thank you very much. We will hear next, if I can find it, from Attorney Sheeran.
All right. Good morning, Your Honors. May I please the court? So there is no error of law that was made by the Worcester Borough District Court or the Worcester Superior Court in this case. They both decided to overturn Chief PAULHUS's decision that Mr. Dwiggins was unsuitable to possess an LTC. But Mr. Dwiggins is a suitable person to possess an LTC based on the statute of General Law, Chapter 140, Section 131.
But aren't the chief's concerns warranted? I mean, they've been to the house on numerous occasions. I think the wife had made some reference to, if I had a gun, this, that, or the other. The son obviously has had some problems and some issues and the knife situation. So wouldn't we all be saying, if in fact he did get a gun, and 2 years later there was a shooting in his house, wouldn't we all be saying, wow, who thought it was a good idea to let him have a gun in that house?
I mean, I agree with that. I understand that that is a risk, but this is somebody's Second Amendment right, and it's being judged on their behavior alone.
This statute comports with the Second Amendment, doesn't it?
Well, just to have a license to carry and have your right to bear arms.
What?
Sorry, what was your question?
I don't understand what the Second Amendment has to do with it. You're not saying the statute violates the Second Amendment.
No, not. I'm just saying that somebody's right to bear arms or somebody's right to have a license to carry should be, their suitability to have that should be deemed on their own behavior and conduct,
Well,
not
under
that of a third party.
Bruin, under Bruin, they don't have to have a reason,
Yes, correct.
but no one has ever said that it must be based on their own conduct.
Well, under the statute for suitability, it must be based on the applicant or licensee's conduct.
Well, let's talk about small Roman numeral 2, which has now been removed from the statute, but that was in place in 2020. 1 talks about behavior, exhibited or engaged in behavior.
Correct.
It doesn't say that under 2 at all. It talks about existing factors that suggest that if issued a license, the applicant or licensee may create a risk to public safety. Why isn't his house is chaotic, there's violence with knives in there, the police come all the time, his wife is mentally ill and has threatened to blow a cop's head off if she had a gun, and so those existing factors suggest to the chief that if they give the applicant a license and he takes it into his house, that may create a risk to public safety. It doesn't say behavior, right?
No, then the second part does say factors, but it also does say that the applicant or licensee. It doesn't say factors that are exhibited from a third party that may create a risk.
Well, if he brings it into his residence where these people are, that may create a risk of public safety. It's not saying culpable conduct or he's the dangerous one. 2 says existing factors, and it clearly isn't limited. They knew how to say limited to behavior. That's Roman 1.
Well, I would argue that these existing factors, whether Mr. Dwiggins' wife or son had exhibited all of these occurrences in the past, if you were to uphold Chief Paulhus's decision, that would be assuming that Mr. Dwiggins would be irresponsible.
No, it wouldn't.
It would, though, because
It's a license to carry a gun in your residence.
yes, but
So
under
he's
the
going
law,
to take it into his residence, and these people are going to get it.
but under the
maybe.
law, it would have to be safely locked up, and it's assuming that he wouldn't be following the safety procedures that come with getting a license to carry, that would make the gun accessible.
No, it wouldn't even necessarily be that. It really wouldn't. You don't think his wife might figure out the combination to a safe or find the slip of paper that he put on if it's a combination safe, or steal his key when he's asleep? You don't think the son, who wants to kill himself sometimes and wants to face off with people with a knife sometimes, might do the same? He might be as responsible as he could be in there, and still someone might get it.
I mean, that is a possibility, but that could also be a possibility for anybody, where people's friends, family, acquaintances, who they spend their time around, there's always going to be certain threats.
Oh, I think that if you lived in an apartment and your roommates were all violent drug dealers, maybe you wouldn't be a suitable person to get a license to bring a gun in there.
But that's not based off of their suitability.
It is. It's based on the suitability. Suitability can be based on existing factors.
So with respect to existing factors, had the statute read existing factors that suggest if issued a license, the gun may create a risk to public safety, I can understand that. But it says if issued the license, the applicant may create a risk to public safety. So how does the applicant create a risk to public safety? Or how does this applicant create a risk to public safety if issued a license?
They don't. I'm arguing that there is no risk to public safety based on the circumstances of this applicant and this licensee.
The chief denied the permit on the ground that the applicant has never held a gun before, doesn't know how to use one, hasn't taken a course to see if, to train to have a gun, and just say, of course you can get a gun, but I don't issue them to people unless they've taken a gun safety course. Can they do that?
I would argue that I know that they do have very broad discretion in deciding whether or not to issue somebody.
Based on suitability?
Yes, correct.
So you think someone who didn't take a gun safety course would be unsuitable?
No, I do not.
Could be unsuitable?
They could be, but I don't think that automatically presumes that they are unsuitable because of the standard. There's no credible or reliable information that.
We do have a case, I know it's before this language, that says unsuitability includes not having, that a chief was upheld and not, giving it to someone who hadn't taken a gun safety course. That's McNaught.
Well, then in that term, then yes, I would say that that obviously plays a factor in it. And I'm not denying that they have an immense broad discretion to deem someone unsuitable, and it's not statutorily disqualifiers. It's based on what they see, the factors, the behavior, the conduct that they're engaged in. But I would argue that despite this broad discretion, the discretion does have to be used in a reasonable manner, and it can't depart from the language of the law as written.
So what's the difference between 1 and 2? Because they both have to, you're saying it all comes down to the behavior of the applicant.
Correct. So the one talks about the behavior and the conduct engaged in by the applicant or the licensee, and whether if they were given an LTC, that would cause a risk that the applicant would cause a risk to safety. The second one is whether there are factors that exist that would, if issued a license, would cause a risk of behavior a risk to the public from the licensee or applicant. It's still directed on the person.
Can you give me an example of what would fall under the second category?
I mean, I think they are almost one and the same. Arguably, I do know that they're two separate, 1 and 2 divided by or, but also I would argue that behavior and conduct that's exhibited is a factor. And I think that basically
Well, it must be factors beyond that that are covered by Roman II.
But there's nothing in the case law that defines what those factors could be.
And yet you have this case here. So what are the factors that
Correct.
define what the...
They got rid of that language.
Well, with that being said, I believe that, yes, that language of the factors is not defined. And it could be open-ended, you can interpret it in multiple ways. But the language in the statute that is defined is based on the applicant or the licensee. It doesn't say whether the third party's behavior or the third party's existing factors may cause a risk. It's based on the sole person itself. And
so why can't it be the behavior of living in that atmosphere, continuing to live in that atmosphere that is so fraught with danger?
because, well, just taking Mr. Dwiggins, for example, his son and his wife, they're both adults. Mr. Dwiggins can do his...
Neither of them could get a license to carry, right?
No, exactly. He can do his part to manage his household, but in the end, he's not responsible for their
Justice Singh
character.
didn't say manage the household. Justice Singh said living in the household.
So, but would you expect somebody to divorce their wife just because you want
No,
a license to carry?
I absolutely wouldn't. I think that would be terrible. But it may render them unsuitable to have a gun there.
But then again, you're also going to the factor that he would be, you're assuming that Mr. Dwiggins is going to be irresponsible or that he's going to leave his gun out without even finding him suitable.
No, I think that's got to be within the judge's discretion to determine how much risk there is. I mean, let's say they found like he leaves his keys places all the time. So now now the chief could not let him bring the gun in there. Like, I don't think there has to be evidence that this particular person has been irresponsible. The question is there an existing factor? And I would think living with felons who commit violent drug crimes might be a factor, and maybe living with people who use knives in domestic violence situations and about whom the police have been called 30 times, that might be a factor.
No, I agree with that. And I do think that it's something that can be considered, but I also think that this is if you were going to base somebody's suitability off of the people around them or the behaviors of people that you live with or spend most of your time with, then I guarantee many of the LTCs that have been granted this today, there's situations where there's somebody in their household that may not be stable mentally or have been addicted to drugs or involved in crime. But to deny every single person LTC just because of the people's behavior that they live with seems very unfair against
It might be
their
unfair,
right.
but the statute has these words in it.
I know, and it does, but I do think that even if you're talking about existing factors, it's still saying, the second part of prong 2 is saying whether, including the existing factors, the applicant or licensee creates a risk. And I don't think
By bringing a gun into a house in an unstable environment, maybe that's more consistent with public safety.
But Mr. Dwiggins has done absolutely nothing. The chief police
The
can...
question under number 2 isn't what he's done in the past, it's whether he may create a risk to public safety. And he's going to go into this house with the gun. That's what the license is for. And the house is chaotic. 80 police calls. That's the reason everyone says this is reasonable, is because it's dangerous.
I understand where you're coming from, but I also would just like to note that Mr. Dwiggins' son also does not live in that premises.
I don't know anything about that. I know that
The
he does.
legislature had wanted to consider conditions that exist in the household. They could have said conditions that exist in the household.
Exactly. And that's not what...
Or maybe they wanted to
language
consider
says.
even more things than that, like all the existing factors.
But then if you look at all the existing factors, no one would ever be able to have an LTC.
I'm guessing there's plenty of people who have guns, almost all of them, I'd guess, who are safe having them. Right? I think most people are probably suitable gun owners.
But Mr.
if they
Dwiggins
aren't on the
is
long
suitable.
list of things that exclude you.
Because there's no credible or reliable information, though, that suggests that Mr. Dwiggins himself is unsuitable.
Well, that's Roman 1 again.
I know, and I do understand that prong 2 does suggest to the factors, but even my brother here was relying on prong 1 as well, and in that aspect, it is not in the licensing authority's broad discretion to be able to to be able to differ from the actual language as written in the statute that clearly identifies the risks and the behavior and the factors existing to the sole applicant and licensee himself, not to other people surrounding him or that he may associate himself with. And I believe that if you were to deny somebody their license based on their acquaintances or their family or who they live with, the behavior of those people, then that almost takes away the power and the intent of the relevant case law and the statute itself.
You think a person who lives with drug dealers who engage in violent drug dealing, those are just his roommates. You think he can get a license to carry? You think he's suitable?
I think that there would need to be a suitability determination based on him alone.
Yeah, he's never done anything.
Then yes, he would be suitable looking
To
at
bring
him
a gun in
only.
to where these violent criminals are.
But that's just assuming that he's acting with these violent criminals, and there's no credible evidence of that. So with that being said, with that being said, the Superior Court and the District Court, both, there was no substantial error of law when they overturned Chief Paulhus's decision to deny Mr. Dwiggins his LTC, as Mr. Dwiggins is suitable, and if there is no further questions, I would rest on my brief.
I see no further questions. Thank you for an excellent argument. Incredibly interesting case. So thank you.
Thank you.
It is submitted. This brings us to our final case of the hard to believe but still morning. This is number 231091, Woodley versus Philip Morris USA, Inc. We will hear first from Attorney Chesson.
Attorney Chesson, follows his paperwork.
when he's ready, we'll hear from him.
And then there was one. Good morning, Your Honors, and may it please the Court. Scott Chesson from Shook Hardy for the appellant. We've raised two issues in the briefs, the sufficiency and Dr. Wester's testimony, and unless the Court would like me to do something different, I will address those in that order. So, our sufficiency argument is not complicated. The plaintiff testified that there was nothing Philip Morris could have done that would have prevented his injury.
Are we to consider the cognitive aptitude of the witness? I mean, we're talking about a witness who has some limitations. We're not even talking about the reasonable person.
Right.
We're talking about a witness who has some. We had a hearing on whether the witness was even competent to testify.
I understand.
Now we're gonna hang everything on with this limited witness. Could he think of?
So I understand the question, and the circumstance might be different if he were a pro se plaintiff. He was not. He was represented by competent and experienced counsel. He was asked a question in cross-examination.
The question was just what could he think of? Could he think of anything?
Right. The question...
That's not the same as saying if you'd been warned, because you didn't ask him because you didn't want to hear the answer, maybe the other side didn't either, but you didn't say to him, if there had been a warning that said this will kill you, would you have stopped smoking? And you didn't ask him if there was a warning that this will could give you cancer, would you have stopped smoking? You asked if he could think of anything.
You can't think of anything that Philip Morris...
I might be able to. You could have gone out of business. You could have not sold cigarettes at all. You could write, there's a million things.
I understand that. In the context of this case, where this is the plaintiff testifying in support of his own case, where the complaint in the case alleges that had he been given a warning when he was a child about the dangers of smoking cigarettes, he would not have smoked and he would not have gotten sick. And in the context of the series of questions he was asked, because it was preceded by, you saw this warning in 1966, right? Yes. You understood what it meant? Yes.
And they were all leading questions. I mean, yeah, you let them right into it. I get it. But nevertheless, what else you got? What else you got?
Well, my point, I hear the Court's skepticism, but there's a reason why there is a storied line of cases from this Court and the SJC that says when somebody testifies about what their own feelings and motivations are, we take them at their word.
But the jury could have read this as not being that.
Right, and I'm saying, and I understand we may agree to disagree, I'm saying there is no way to read that answer, particularly given the dog that didn't bark. Because
I understand, but you let him through it. He says, yeah, I guess. Then you say, no.
True, and then he says yes, but it was really an I guess, right?
Well, to understand...
We'll take that for what it's worth.
Right, so to understand the context, and I hear what I'm getting from the bench, and I will move on, but if I can close out this point, my partner, who's sitting right to my left, who started that exam by saying, Mr. Woodley, we had you on deposition for 2 days. We got a lot from you. I'm going to ask you questions that you and I both know the answers to. Everyone in the room knew what that answer was going to be, or otherwise he was going to be impeached, because he was asked that question in a non-leading fashion at deposition and said, no, I can't think of anything. His counsel knew it too, and then did not address the topic at all with him on direct. This is the answer that came out on cross. And then on redirect, very first thing out of the gate was, you remember that answer you gave? And then counsel asks the lead-up questions, but then doesn't ask the world's simplest question that would have put this to rest. He said, you didn't know that cigarettes would cause cancer, did you? No, I didn't. Would you have liked to have known? Yes, I would have.
Why? Can a jury not infer that the reason you want to know is you'd act on it? I mean, did he seem like someone interested in the abstract nature of everything he did, or?
This is why I go back to the case law. And we cited the Frazier case in our briefs, and there's 12 others that say exactly the same thing. Frazier says a party is bound by his testimony concerning his knowledge, motives, beliefs, etc., and he has no right to ask a judge or jury to disregard it.
But counsel, you started your argument saying that he testified that there is nothing that could have been done, but he didn't testify to that.
I have the, no one's like hiding from what the testimony was. Yes, it was a yes answer to a leading question, and the reason it was leading was because he had been asked it before. The question was...
You want to finish your question?
Oh, I'm sorry.
Go ahead.
I thought I was being corrected. I apologize about that.
No, I would like to hear this.
As we sit here today, you can't think of anything that Philip Morris could have done differently to prevent your injury.
Right, that's a different question than how you opened. I can't think of anything that you could have done is not the same thing as there's nothing you could have done, right?
Oh, that's interesting. I can't think, you're saying there's a difference between I can't think of anything and there's nothing. And that's...
There's nothing you could have done, which is what you needed.
Right. Well, respectfully, I would disagree with that. Like, this is where I was going with the case law. The case law is about what he thinks. There was an objection to this question when it was initially asked, and there was a sidebar where the judge eventually said, you can ask him about his state of mind because his state of mind is what's relevant. What he thinks is both the relevant question and it's what he's bound by.
I understand.
Okay, I do think you should move on. I think we all understand.
I'm getting that. I'm at my 8-minute mark, so I'd like to. I'll talk about Dr. Westra. And in my view, this is arguably a simpler. I mean, the remedy is different, but I don't think there can be a whole lot of disagreement, reasonable disagreement, about what happened. This was a 180-degree change in testimony by an expert witness who had an obligation to disclose his opinions. Here's what he said. I got one piece of paper here where there's a lot of noise in the briefs, but I think this can be boiled down to. In his report, this is the first volume of the record appendix, page 144. Here's what he says about alcohol. He says, Mr. Woodley's history of alcohol abuse may have also played a role in the development of his original...
Look, I mean, I think we've all read the testimony.
And
there are, I agree there are some things that he said at the initial deposition that can at least be read. I mean, they can be read both ways, actually, but that one could read them to say, although every time he's asked this directly, he says no, could it be an independent factor? And what he says, frankly, repeatedly, is if you're a smoker and you add alcohol to that, then alcohol can be a contributing factor. I can't even tell, since he did drink and got the cancer, if he didn't drink while smoking, whether the smoking alone would have caused it. But the smoking was a but-for cause of it, maybe accelerated by alcohol. There are a couple places where he says something that sounds like, could alcohol alone have done it? And I think there's one place where he might say possible, although in other places he says, no, that's not what happened here. And he says, oh, are you saying, I don't remember the exact verbiage, but are you saying that he's saying, oh, but if you're saying it, did alcohol alone say it? I don't think we can say that at all. But let's say he changed his testimony.
Right.
You were given a chance to cross-examine him, even an extra chance to cross-examine him. You were given the opportunity to have a continuance to get another expert. The judge offered you all these things. And so don't you have to show but no, a mistrial was required?
Yes, we do have to show that, and I'm not running from the standard. It is rare that it happens. But those options could not have solved the problem. The cross-examination, and my brother at the bar, Mr. Fossey, I think did, and this is what the judge said, did the best he could with a surprise. But the cross-examination was all impeachment with prior inconsistent testimony. You said at the depot, you gave a clean yes, and now here at trial, you're qualifying it with this.
Isn't that what normally happens when someone deviates from prior testimony?
But there's a difference between an expert and a lay witness. A fact witness who jumps his depot, that's how you impeach him. There's a reason for Rule 26. It presumes that even the best lawyer can't cross-examine an expert unless that lawyer happens to be an oncologist himself. The difference was stark. He said prior to trial that alcohol may have played a role. He said at trial, what he said is, I'm not aware of alcohol causing subglottic laryngeal cancer. If we had known that was
Well,
the issue,
he did say, and I don't know what you knew, and I'm assuming here that there was a serious change. He did say hypopharyngeal.
one time.
Yes, one time.
And
But the
in
people he was
response-
talking with are familiar with this cancer.
Oh,
a lot, right? You guys are not like
No one is-
two parties who are just speaking
No one is
past
a
each
babe
other.
in the woods here, and no one is saying that anyone is. But I think it's significant that this witness, a very experienced witness, when asked a hypothetical question about independent risk factors, at one point says the word hypopharyngeal. But when asked forget when asked, when he writes his own report about this cancer, he says, I think alcohol may have played a
I'm
role."
willing to say,
Yeah,
although I don't think it's necessarily true, I'm willing to say. So then on the stand, in a deliberate attempt to close the spigot, says every time, hypopharyngeal, and maybe that was a change, although, in fairness, the lawyers on your side of the deposition never followed up on hypopharyngeal. They just asked about laryngeal in each subsequent question, where, of course, the answer is going to be yes.
So, and that's,
But that's not-
Your
but
Honor
I'm-
says in all fairness, I feel compelled to correct Your Honor a little bit. He wasn't just asked hypothetical questions.
No,
That's
I
what he
agree, although his
said on the
answers
stand.
seem, I agree, I'm saying there's a change.
Right.
I just don't understand why more cross-examination, you're just making this up, blah, blah, blah. You didn't say it before, blah, blah, blah.
There's a reason. So, plaintiffs call us out on it in the brief. We drop a footnote to an article that they say is not peer-reviewed, it's not reliable, it's not in the record, et cetera. Our only point, and that may be true, I don't know. I am not an oncologist either. Our only point in saying that is we're saying it's not necessarily true that Dr. Westra was right, that this is an indisputable medical scientific position that these kinds of cancers can't be caused by alcohol because of the geography of the tumor. Had
You
we
were given
known
an
this was an issue-
opportunity to get another expert witness.
Right, which is number one, not something one can do right in the middle of trial. But number two, the bell had been rung. There was the treating doctor had been, examined and cross-examined by this point, and no one on our side had examined this issue because it wasn't supposed to be in play. We had opened. We'd opened on this defense. Had we known this is the reason for Rule 26. It's so that you go out and you get an expert and you ask him, evaluate this expert's opinion, and what do you think? It's possible we would have found the world's greatest expert on subglottal cancers who would have said, Dr. Westra's all wet. It is also possible we would have found the world's greatest expert who said, ooh, you know what, he's got a point, and maybe we wouldn't have run that defense. What I'm saying is...
Did your expert contradict Dr. Westra?
Our expert, who is a practicing ENT and is good at what he does, but this is not his area of study, said on the stand exactly the same thing that he said on...
Wait, laryngeal cancer isn't his field of study?
No, laryngeal cancer is, but this distinction between this thing about can alcohol make its way down into the subglottis, and is alcohol a risk factor for subglottal laryngeal cancers? That is... They made a big deal of it in closing.
Even the expert said it could, but you'd have to be aspirating alcohol.
Right, and he said, look, the fact is the guy was a pint-a-day drinker of hard liquor, and this is a thing that happens with alcoholics is the muscles relax, and sometimes you choke on things, and it does get down there. And yes, he said that, but my point is this was not... I'm taking your Honor arguendo at your word that, let's assume it was a change.
Yes, of course, yeah,
right.
yeah.
There is a reason we have these disclosure rules, and it's so we're not having this conversation about what could we have done better. We shouldn't be in the position of having to say, well, maybe the thing we did at trial is the thing that would have happened anyway. The rule exists in order to discourage this type of gamesmanship, and with a witness this experienced, with counsel this experienced, it beggars belief that this was all just an accident. And our point is just...
Well, the judge didn't find that it was a deliberate switch, And we're not going to.
I know, I understand,
we
and I'm not here to cast aspersions on my brother at the bar. My point is, we shouldn't be in this position. So that, I see my, well, I'm only at
One other question for you, though.
Yeah.
He was, Mr. Woodley was a pint-a-day drinker, I heard you mention.
Yes.
And at one point, he was drinking a pint of, I think it was whiskey or bourbon or something a day.
Yeah.
And then something happened, and he changed from that to drinking a pint of vodka. What was the intervening act that made him change?
I believe the answer is there was rehab and then there was a relapse, but I'm looking to my partner who was the trial lawyer and who's nodding, so I think that's, yes, I think he went to rehabilitation, quit drinking, and then eventually relapsed.
Do we know why he went from whiskey to vodka?
I do not personally, and I'm being told through a subtle shake of the head that we do not collectively.
All right, your time has expired, although, okay. I see no further questions. Thank you very much for an excellent argument. We will hear now from, I never have the right sheet anymore. We will hear now from Attorney Tyne.
Good morning, afternoon, Your Honors. May it please the Court, Michael Teen, on behalf of the appellee Calvin Woodley. Shall I address issue 1 first or issue 2? What is
up to you, but can you put your microphone a little closer to you? Super.
Happy to. Let's address number 2 first. Your Honors asked about whether there was a witness who testified that they had a doctor who testified contrarily. Yes, at RAIV 164, you will find that Dr. Gregory Bissell, they did in fact call their expert, and Your Honors are correct with respect to the fact that there was no prejudice. I'm kind of taking the last prong first, that Dr. Bissell, who was their expert, who they had retained pretrial and who had been deposed, he said very squarely on that page that location did not matter. There was full and very, very full, not only cross-examination.
I'm sorry, RA 4164? I see.
Oh, sorry, RAV. Sorry, RA.
Index, yeah, okay.
Volume 5-164, I apologize. In addition to the extraordinarily unlimited cross-examination that was conducted, but I have to step back. We don't accept the fact that even, this issue is governed by CASE, K-A-C-E, the case, and the very first, the precondition to even applying CASE, which says that this court defers to the broad discretion of the trial court as to admitting or excluding the testimony of an expert where that testimony had not previously been disclosed. We beg to differ. I do not think, most respectfully, if you look at what the testimony actually was and what the issue was, that we even get to CASE, because I respectfully submit that this issue was disclosed, and I would direct Your Honors to RA 1, 221.
I'm sorry, I'm just reading these pages, and I'm not sure I'm seeing where he says it's only
at RAV 164, page 1857 of the transcript, at lines 13 through 15. Dr. Bissell is asked by counsel for the defense, question, does the location of a tumor in the larynx make a difference when you're assessing causation? Answer, it does not.
Okay, maybe that's, I mean, I see how that's contrary to saying, but there's no specific questions about hypopharyngeal versus glottal.
And I can address that. He does specifically, I want to finish my point, and I'll put that to the side, but I'll answer your question right now, which is the only arguably different opinion really, that colorably different, and I respectfully beg to differ with my brother and sister counsel over here. The only thing differently that happened on direct examination was that Dr. Westra said this was a tumor that arose in the subglottis. But then immediately on cross-examination, he was crossed on that, and he clarified, and he said, no, I thought I was very clear. This was a tumor that arose in the glottis and extended into the subglottis. And he was very clear in correcting that. That was the only difference. I see Your Honor may want to ask a question. So let me pause for a second.
Well, I just think that the real difference is at least two of his answers in the deposition, some said the opposite, indicated that it was possible that alcohol alone could have caused Woodley's cancer. There's at least one answer that seems to say that. I understand. And the other one, they ask about his tumor, and then by the end, his answer is really about a little more generic, but the question was, but there's another one later on where he says it. I understand it might be contradicted elsewhere in the deposition. He testifies that that's not possible because of the location. And so that might be actually a rather important change, if that's a change. So my questions before assumed that there was that change. And I guess, leaving the question, why shouldn't a mistrial be declared? I said to your brother, colleague, witnesses change their testimony all the time. You cross-examine. And he says these are expert witnesses. The reason we ask for these disclosures is so we'll know what they're going to say, so that we can have other witnesses lined up and so on. I'm still interrupting you, but do you want to, what's your answer to that?
First, he doesn't say it's not possible. He doesn't say that. His testimony, he's very clear. He's first of all, in his deposition at RA1, 221, 224, 230, and 280, he describes the following, and I submit to your honors, there is no question, this is 100% clear, that he says, he makes a disclosure that was no different and fully consistent with his testimony at trial. And I'll tell you what the disclosure is in a minute. But even if you were to find that it was arguably slightly different, because it used different words or the same, Case talks about that. And Case says it's not a different opinion where it's the development or link to the natural opinion. Here he's negating something that the defense is saying. His opinion that smoking caused it is the same.
I've asked you to assume that and obviously we're going to look in detail at the deposition and the trial testimony. We already have, but
yes,
certainly before an opinion is written, it will be examined more fully. If we were to conclude or assume that in a deposition a doctor said, is it possible that alcohol causes this? Yes. And maybe doesn't talk about aspiration and everything else, just as possible, yes, but that's not what happened.
Right.
And then he testifies, well, alcohol doesn't come to contact with this, so it couldn't have. If that doesn't come out, and again, I don't know both sides can play game. I mean, whatever, you guys have been doing this a long time. And you guys have been doing this a long time, and I'm sure you're both very skilled at both asking questions and framing arguments beneficial to your side. So I don't want to get into what's deliberate and why they didn't ask this versus what. Assume it. Why would that not warrant a mistrial here?
Absolutely could not. If you follow Case, which is binding on this court, the trial court, assuming, which I candidly do not respectfully disagree with.
I understand your disagreement with the premise.
Yeah, I'm going with I'm not going to buck the hypo. There's no question that a mistrial ought not be declared if you follow Case, which is number one. You're reviewing this issue for abuse of discretion. This trial judge was the very picture of exercising discretion here. He was very self-critical. He even assumed it was a surprise, which I submit to your honors, I don't just submit, I 100% believe that the record establishes without cavil that the opinion was disclosed. And so we don't even get to this. But the trial judge, very carefully said, well, I'm going to assume, even if, he was surprised, maybe, let me do everything I can to remedy this. And Your Honor's correct. The idea that the bell couldn't be unrung, Your Honor had it, as did Judge Ullman, when he said, this is impeachment by contradiction. If you think he varied from his pretrial opinion, impeach him. If he said pretrial A and now he's saying not A, show him his report. My brother counsel referred to his report, but not to his deposition. He was deposed, Dr. Westra was, for 2 days. And Judge Ullman remarked, and so did the witness when he was asked, you didn't get to the nuanced questions. And in fact, the witness was asked too.
Okay, but we're fine.
Sorry.
I get all that, but take my hypothetical premise that there's a change,
Yes.
like I described.
That's
And you say, which seems reasonable to me, impeachment by contradiction is normal.
many remedies.
But your brother says, not in an expert witness case. That's why we have these disclosures. An expert changing their opinion is different, is it?
Not under case. Case is the playbook, is the instructions manual for us to follow. We're not writing on a clean slate here.
I understand that. I'm asking you about what the slate says.
Yeah, the slate says the trial court has broad discretion in handling it. And if he did not abuse his discretion, then the decision to admit the testimony ought be affirmed. And I say he didn't abuse his discretion because, number one, he exercised his discretion in a very painstaking throwaway. Two, he exercised his discretion by allowing certain things to happen and offering a menu of items to the defense, only some of which they took advantage of, like extraordinary cross-examination, admitting the report itself, over and over emphasizing certain things about did you or did not use the word subglottis this number of times in your report, which was really a little bit over much in terms of using the report that way, but the judge still allowed it. And even to the fact that your honors will see that counsel for the defense at trial said, sidebar, we destroyed his credibility. I can give you the cite if you want.
I saw that.
Yeah, and so they obviously felt that they had their inning with Dr. Westra. And so that, under case, you don't just have to find an abuse of discretion, you'd have to find that there was prejudice. How could there have been prejudice when, first of all, they mentioned the treater, that's correct. The treater, you'll see, Dr. Faden, F-A-D-E-N, drew a diagram and even said to the jury, this is where the liquids go, this is where the smoke goes, no objection. You had direct examination, and it wasn't until, I think, 57 pages after he discussed the location as one of the grounds for his opinion that they objected or moved for a mistrial. So that it was no contemporaneous objection. That's another reason that mistrial shouldn't be declared. Furthermore, they had full and fair cross, and then full and fair cross again. Another reason why a mistrial shouldn't be declared. Further, they were given the opportunity if they wanted to retain a new expert. They didn't. Another reason a mistrial shouldn't be declared. Further, they did, in fact, call their testifying expert, who testified at length and in detail. No, you couldn't choose between, you couldn't tell, he said, between smoking and alcohol. Therefore, at best, it was an equipoise, if credited, which the jury did not credit, meaning the plaintiff could not have gotten to 51%. The jury rejected that, but he did testify that. Further, the testimony that I read at RAV 164, where their expert specifically testified that location didn't matter, location didn't determine in and of itself. I should not misquote, where he said, does the location of the tumor make a difference when you're assessing causation? Answer, it does not, meaning.
Is Chase an unpublished case?
Case, K-A-C-E.
Oh, case, not
K-A-C-E. And it is.
I got it. Thank you.
An SJC case.
No, you're right. I see. I made a mistake.
And I'm running out of time. So they had every opportunity, and there can't conceivably be any prejudice. And if you look, the disclosures that Dr. Westra made when he was deposed, this isn't a situation where, as the rules contemplate, that there don't have to be a deposition. That isn't that case. There was a deposition, and I submit to your honors, when you look at RAI 221, 224, 230, and 280, where he talks about the hypopharyngeal cancer, as where alcohol causes cancers of the pharynx, heavy drinkers are at risk of hypopharyngeal laryngeal cancers, and he gives the basis, which is his clinical view. And finally, I would just switch to issue number 1. And I would say this is squarely governed by Evans. Justice Singh, you absolutely got it correct. In reading their brief, it elides, or it is a little casual in summing up the question. The testimony itself is important. The trial judge himself, viewing it, realized, as Your Honor, Justice Desmond recognized, that you were dealing with someone whose competency they himself had challenged. And they asked this question that I have very much difficulty even understanding and how to answer it directly. And furthermore, this issue is squarely governed by Evans, which says, as Your Honor, Justice Rubin noted, it doesn't say heed a warning in the air. It says heed a warning mean and avoided the addiction. And the cases that Evans cites, both of these SJC cases, both Wolf, which they rely on, and blanking on the other name, was, I see my time is up. May I just finish the sentence?
I have 2 quick questions for you.
Take your time, yeah.
One is Woodley an alcoholic?
Was he? He was, yes. He went to AA.
All right. And so, do you know why he changed from a pint of whiskey and then went into rehab and came out and is now drinking vodka?
I don't offhand. I don't know. That didn't occur to me, that issue, as something that I should have prepared on.
I'm just curious if he had learned something in the rehab that changed his habit from drinking whiskey to drinking vodka.
Oh, that would have occurred to me. I saw nothing about that. Rather, I think that there was a time when he was absolutely a very down and out alcoholic, and he went to, the testimony that he gave was that he went to AA and was ultimately able to recover and stay sober.
More? All right, your time has expired. Thank you very much. Thank you both. You're skilled and talented lawyers, and these were excellent arguments. So the case is submitted. That brings us to the end of our sitting for this morning. So I'd like to thank the court staff and the court officer for your, as always, excellent assistance. And we